I declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Secrecy Provisions Amendment, Repealing Offences Bill 2026. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. For people participating remotely, I'm sure that you can see everybody in the room, but I'm the Chair, Senator Jana Stewart. I'm joined by the Deputy Chair, Senator Leah Bly, and also Senator Michaela.
Thank you.
And at different points through the day, we'll also be joined by Senator David Shoebridge. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground on which their objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground on which is claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear. And witnesses should speak clearly into the microphones to assist Hansard for recording today's proceedings. I now welcome Mr. Peter Grest of the Alliance of Journalists Freedom, joined by Mr. Michael Bradley. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you, and it's also available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you appear?
Thank you, Senator. My name is Professor Peter Grester. I'm the Executive Director of the Alliance for Journalist Freedom, and I'm joined, as you mentioned, by Michael Bradley, who is the Managing Partner at Mark Lawyers, who also worked on our written submission. Our starting position is that the government always works better when it's open and as transparent as possible. Transparency is crucial for good government. It reduces abuses of power, it makes the system more efficient, and it promotes public trust and confidence. A degree of secrecy is important, of course, but only around information that is genuinely sensitive or that would be genuinely damaging if it was released. Now, Australia's become the world champion of national security legislation. The former independent National Security Legislation Monitor, James Rennick KC, said successive parliaments had passed 130 new security laws since 9/11. That's more than any other country, and he wrote that 5 years ago in 2021. We do not deny the need to update our legislation to deal with new threats, but Mr Rennick was rightly cautioning against knee-jerk legislation in response to terrorist incidents that often intrudes on rights and freedoms. In other words, those laws have often damaged the principles of the system that Parliament was trying to protect. These amendments are the first significant reversal of that trend since 9/11. We commend the government for taking on many of the recommendations we made in our initial submission to the National Security Legislation Monitor's inquiry into the secrecy provisions. Removing the offence of dealing with sensitive information means it's no longer an offence for a journalist to merely receive a document. Removing the security classification as an indicator of harm is also an important step forward. Overall, we recognise that the proposed amendments go a long way to improving transparency without compromising essential secrecy and security. But the bill before you is not perfect. For example, we believe the terms interferes with, prejudices and harms in section 122.4a(d)(3) are still too vague. The appropriate point for determining criminality is when actual harm occurs. For transparency to be effective, whistleblowers must be able to gather information and evidence of wrongdoing and transmit that to appropriate parties. And sometimes that includes journalists. That's why the term interferes with should be repealed, and both prejudices and harms should either be repealed or clarified. We also remain concerned about section 123.6, which requires the Attorney General's consent before prosecuting a journalist. Now, we recognise that this was intended as an extra safeguard, but we maintain that any time a journalist's case is referred to the AG, their decision, whichever way it goes, will be regarded as political. Instead, we believe the exemption for journalists should be written into law. And we still believe the defence of section 122.56, requiring the reverse onus of proof, violates the principle of the presumption of innocence. Senators, in thinking about these issues, we always go back to the AFP raids of 2019. You'll recall that federal police went to the home of News Corp journalist Annika Smethurst on one day and then to the ABC the next. The stories the police were investigating were outstanding examples of responsible journalism evidently in the public interest. Both relied on leaked classified information, but neither exposed anything that might genuinely damage national security, and both triggered important public debates. The AFP investigations and subsequent prosecution of David McBride for his role in the ABC's Afghan Files story were sobering examples of just how damaging Australia's overbearing security framework can be. The amendments before the Senate do ease that culture of secrecy, but David was charged and convicted of theft of Commonwealth property and unlawfully communicating military information under the Defence Act, and so he would not have been protected by these changes. That's why the AJF continues to advocate for broad improvements to our transparency framework. They include reforming whistleblower laws to give future David McBrides adequate defence, overhauling freedom of information, and introducing an overarching Media Freedom Act that would have prevented the raids in the first place. Those reforms remain overdue and necessary. Without them, journalists and sources are still dangerously exposed and our government unnecessarily secretive. Senators, we've constantly argued that while there is a necessary tension between the work of journalists and the security and intelligence agencies, they are not in opposition. When journalists can freely report on the government while protecting their sources, it demonstrably improves the way government operates while maintaining public trust and confidence. The UK's National Security Legislation Reviewer, Lord David Anderson KC, has said public consent to intrusive laws depends on people trusting the authorities, both to keep them safe and not to spy needlessly on them. Trust in powerful institutions depends not only on those institutions behaving themselves, though that is an essential prerequisite, but on there being mechanisms to verify that they have done so. The AJF maintains that a free, well-resourced media with well-protected sources is one of the most important of those mechanisms. I look forward to your questions.
Thank you very much. We will proceed to questions and begin with Senator Cash.
Thank you very much, Chair, and thank you very much, Professor Grest. That was your entire opening statement, which I assume you've read into Hansard, so we have the benefit of it. Can I just go to Schedule 3? Because we've got Australia's right to know, the journalists coming in later, the Alliance. They don't actually touch Schedule 3, surprisingly, in their submission. And yet I think that that is actually one of the most important parts of the bill when it comes to journalists. So in the first instance, the Porter direction, which did put in place the Attorney General's consent for certain secrecy laws, it appears to be agreed that that is something that could be legislated. It's then the extension out of this particular Schedule 3 to all offences in terms of secrecy law. Can I just get you to take us through that further in terms of the potential politicisation of any decision that journalists may then have to curry favour with a particular Attorney General of the day? And there's that tension between the submissions. Some say they like it, it is an additional safeguard. Others, like yourself, say back off, because.
Yeah, and I'll invite Michael also to jump in here as you see appropriate, Michael. But just briefly, my view, our view is that we recognise first, of course, that the Attorney General is the first law officer of the land. But nonetheless, they're a political figure. They're a member of the cabinet, they're a part of government. And so we feel, that there is always going to be that tension, as I mentioned, between the media and government. If and when an Attorney General makes a decision either way, it is always going to be regarded publicly. No, there's always going to be a mining for motives. Why did the Attorney General make this particular decision? Was it because there was no legitimate reason to prosecute, or was there some other hidden agenda that we're not aware of? Was there some attempt to curry favour? And likewise, if you're a journalist, being mindful of the Attorney General's capacity to either approve or reject a prosecution, I think is always going to have an influence on the way that you cover your stories. I recognise, as I said, we acknowledge that there is value in having an oversight, but this politicises the decision in a way that I think is inappropriate. We've always argued, and this is in our submission, that we think that protection for journalists should be written into the law as an exemption.
Yes.
And again, I'm happy to discuss how that might be defined, but that would be our preferred position, because I think it does avoid the potentially awkward situation in which an Attorney General's decision to prosecute or not to prosecute is going to be seen as political.
Just on the Schedule 3 as well, if I could just take a step back to the Porter direction, and you've referred obviously to the 2019 raids. In terms of the Porter direction, what's your views on that, and perhaps maintaining, and that's still a live direction today, so you still require consent. Could that be legislated? Is there a need to legislate, or can you merely rely on the direction?
Michael, do you have any thoughts on this?
Yeah, look, I think, we recognise that many people take the view that, and there's a good argument for maintenance of the Attorney General backstop in these types of provisions. The difficulty that we see, as Peter was alluding to, is that the role of the Attorney General has changed over the years, and in particular in terms of the public perception. So it has become a more politicised function compared to how it was historically. And so the public trust in that has been diminished. And then that sort of plays into how the media is likely to perceive that function, how they're going to conduct themselves, having regard to the way they may preempt how any particular Attorney General is going to make decisions or not make decisions. So it's an example of where, perhaps in earlier times, inserting the executive into a legislative and sort of judicial framework used to work as an effective backstop. We don't think that works any longer, and in fact, it's not in anyone's interest, including the government of the day, for that sort of merging of functions to exist in this context. And when it comes to the question of press freedom, that is such an important and fundamental function of democracy that it should be protected legislatively. And if there is any grey area there, then that should be a function of the judiciary, not the executive. So it is a separation of powers question fundamentally, but we accept that there are very reasonable minds on the other side of this argument.
Could I ask you, Mr. Bradley, then, in terms of the Porter direction, that was a direction, which had the force of law, obviously, but not legislated law. In terms of the Porter direction, Where do you stand on that versus what's proposed with Schedule 3 is the actual embedding in legislation, not just the port of direction, but actually going further to cover all secrecy offences?
Look, I'm not sufficiently familiar with the port of direction itself to comment directly.
So just so you know what the port of direction was, it basically was Christian Porter, when he was the Attorney-General, put in place the direction that for certain secrecy provisions, the prosecutions, this was in reaction to the Annika Smethurst, you had to seek the consent of the Attorney-General. Okay? So it's already there for a number of offences. This takes it further but embeds it into legislation. Could you live with a direction?
Well, I mean, that is a question for the executive. You know, if the government, as a matter of policy, considers that you know it should make the DPP subject to the Attorney General's policy in terms of, you know, the choice of prosecution in these types of cases, then that's a matter for the executive government, and you know, we wouldn't really have anything to say about that, because it would operate as an additional layer of protection. We don't think it's adequate, and we think that, you know, if the law is so broad, or remains so broad in terms of the potential for journalists to be prosecuted for doing their job, and it relies on executive action to kind of water down what might otherwise be draconian steps, then that's not adequate.
Can I ask one other question as well? And it's a direct contrast with, say, a prosecution for crimes against humanity. The Attorney-General's consent is required for a prosecution for crimes against humanity. However, it's required at the beginning of the process, before any arrest or charge is actually laid. In terms of Schedule 3, that's not what Schedule 3 does. The police can actually arrest and they can charge, so the journalist can still be left in limbo. They've been publicly arrested, publicly charged, and then the Attorney-General is requested to give consent to the prosecution. How do you see that playing out in terms of that time frame?
Well, what that speaks to is the major problem, or the evil here, is not so much a journalist's risk of ending up in jail. It's the choices they're going to make because of the chilling effect of the law itself. Mm-hmm. So obviously the prospect of, you know, being raided, arrested, having a search warrant executed on your home, having your phone gone through, all of that has a dramatic chilling effect on journalism and on the media. And so, you know, if that remains the legislative setting, then that chilling effect continues, and that's not, in our view, sufficiently well balanced. So the fact that the Attorney General may then step in and say, okay, well, no, we're not prosecuting this guy, it does come too late, and it's not, you know, it may be beneficial in particular circumstances, you know, as it was with, say, Annika Smethurst, that, you know, that decision was then made, but it was too late. You know, a lot of damage had already been done to no good effect. And as Peter said, you know, the work that was, the journalistic work that was involved there was clearly public interest. So, it remains not sufficiently balanced.
So if I was to say to you, does Schedule 3 stay or does it go in terms of the current bill? What would your advice to the committee be?
We would say that, you know, our preference is, as we've submitted, that the Attorney General should be removed from the field in terms of... And you
strengthen the journalist protections, as you then later say in your submission. There's another way of doing it.
Yes, exactly.
Correct, yeah. I mean, the starting point... Sorry, Peter. The starting point should be transparency and opening the field as wide as possible for journalists to do their job. Sorry, Peter, I interrupted you.
No, I was just going to endorse what you've just said, Michael. That the problem, there are two parts of the problem. I think Michael's really identified one of the key parts of this. That the challenge for us as a media freedom advocacy group is identifying the counterfactual. Yeah. We can't quantify stories not told. Australia isn't throwing journalists in manacles and ripping fingernails out in the way that they are in many other authoritarian countries, but we do know demonstrably through research that my colleagues at the University of Queensland have been doing that the current environment means that stories are suppressed, that whistleblowers and sources are feeling vulnerable and exposed and pulling out of stories, that lawyers are advising against certain stories because of the legal risk. We can't put numbers on those stories that have not been told, but we know that they're happening, and I think that's damaging as a result. And what Michael has just articulated is the way in which Schedule 3, not just Schedule 3, but Schedule 3 is certainly a part of that places the emphasis at the wrong end of the spectrum, okay? Places it, as you said, at the end of the process rather than at the beginning, which is why we've been consistently arguing for sufficient journalist protections and exemptions up front rather than having it back-ended at the whim of the Attorney General.
Can I continue, Chair? You tell me when you...
Yeah. No, you're
good. Thank you. Okay, so that's a great discussion in relation to Schedule 3. If we then go to now the front end and your submission, take me through in particular, because this does appear to be a theme that has been raised through other submissions, introduction of clear harm thresholds, and in particular definitions so that genuine guidance is actually given to people. Take me through where you sit on that.
Michael, do you want to take this up? Because this is a slightly more technical question that I think you might be better placed to answer.
Yeah, sure. Sorry, I'm just pulling up the provision. So I mean, looking at the outset, I'd like to say, as we did in our submission, that the removal of the amendments that are in the bill, we endorse and are delighted to see, particularly the removal of the classifications of secret and top secret as deeming provisions in terms of elements of the offence, and the removal of the dealing offence altogether. But there are still definitional elements there which are problematic. So I'm talking specifically about 122 4A1 D 3 and 4, which so 3 says interferes or prejudices with the prevention, detection, investigation, etc. of a criminal offence, and 4 talks about harm or prejudice to the health or safety of the Australian public. Now, these are very broad terms: interferes with or prejudices, harms or prejudices, and quite low-level sort of terms in a definitional sense. They're not defined in the legislation. From the perspective of journalists who are at risk of being prosecuted for communicating information that they've received from a whistleblower, to take that as the scenario, how they're supposed to work out whether their publication of this information is going to either interfere or prejudice with the prevention, etc., of a criminal offence, or harm or prejudice the health or safety of the Australian public, or is, that's difficult to say. Now, at the extreme, of course, easy to come up with scenarios where that would be obvious, and to go ahead with publication would be, would clearly do serious harm. But But those terms are so broad that, they could pick things up, for example, in terms of the psychosocial health of a section of the Australian public, which, in the current environment could mean, journalists thinking, well, am I going to be prosecuted for publishing something that's, going to be perceived to be anti-Semitic, for example, because it might harm the safety of a section of the public in a psychosocial sense. Now, that's very problematic from a press freedom perspective, and has, potentially reaches deeply and broadly into investigative journalism and good faith public interest reporting, and bearing in mind the reversal of onus is still there, in terms of defence. So for a journalist to think, well, when they're coming to the decision to publish or not publish, it remains just too woolly. And the fact that, there haven't been any prosecutions is not a good thing. That just speaks to the chilling effect itself. It would be equally difficult for prosecutors to work out, whether an offence has been committed. But this is not good legislative drafting. It's too broad and too vague.
Can I also just make the point too that a lot of the amendments shift the focus to the harm.
Yes.
The consequences, to the consequences
Yes.
of a disclosure.
Yep.
Whereas the term interferes with and prejudices
Yep.
maintain the focus on almost at the gathering stage.
Yes.
And I think the good parts of these amendments are those shifts to the focus on the consequences.
Yes.
The negative consequences, the damage that is done. If we maintain these kinds of terms, including interferes with and prejudices, that places the emphasis in the wrong stage of the process.
Can you then give better guidance as to what interferes with and prejudice actually means? You're not, or are you suggesting remove it altogether?
I think interferes with needs to go.
Right.
I think that's problematic. That's one of the points that we made in our submission. I'm not being a legislative drafter, I'm not going to try and necessarily redefine prejudices, but we are concerned, I think I'll underline Michael's point, that the term is too vague for us and either needs clarification or removal.
Okay. Can I ask, and it's one of the things that you and I, Professor, were discussing prior to the hearing commencing, the explanatory memorandum provides protection to people acting in, and I quote, a professional journalistic capacity. Again, one of the themes in the submissions is, what does that actually mean? Who does it capture? And in particular in 2026, looking forward, journalism's very different. Can you please take us through, A, what you think that means, but B, what it should potentially be defined as meaning?
Okay, so let me go back to first principles. The reason that we protect press freedom as a subset of freedom of speech is not because we want to protect a particular class of self-appointed individuals who call themselves journalists.
Yes.
In our view, what matters is journalism, as in the process that lies behind it. We recognise that our democracy requires a source of information produced by people with the degree of ethics and integrity who are capable of investigating and reporting on the activities of the government and supporting public debate. That is contingent not on your job title, it's contingent on the ethics and standards that you uphold and that underpin your work. We think that the word professional capacity makes it problematic, particularly in a world where we're increasingly seeing news producers in all sorts of forms as content creators, YouTubers and so on.
Yeah.
Now, my view is that, and this is why we lean in the definition of the Queensland Evidence Act, which has a standards test. And there's something similar already also exists in the Victorian Evidence Act, where it says that the the journalist or publisher shall be accountable through a complaints process to a code of conduct. It's accountability to a code of conduct that we think is what's key. If we place the emphasis on that, then it in law, then what it does is encourage would-be journalists to stay on the right side of that line of that code of ethics, because it provides a degree of top cover, but also allows the definition to extend to people who we don't normally recognise as journalists, but are, as you said, looking forward, inevitably going to be making up an increasingly large number of people that produce journalism.
So if I look at it here, independent media, including blog and Substack writers, YouTube channels, etc., or people who are deriving their income from that type of activity, it's not necessarily what I call myself.
No, but equally, just because you're a YouTuber producing something that looks like journalism
doesn't mean
that you are a journalist, which is why, again, we go back to the ethics and standards test, that we think that is the defining feature. Now, we are not suggesting, we are not proposing, and none of the examples that we cite of state legislation give the power to the government to decide what those ethics and standards should be.
So what's the current test under the existing legislation?
I'm going to have a look at the definition, but but it doesn't. It requires professional capacity.
Yes.
The question of what professional is, I think, is vague, but also inappropriate in a world, as I said, where a professional implies that you derive your income from that.
Yes,
but again, increasingly, income can be derived from all sorts of content designed to create clicks rather than to produce journalism with integrity. And so that is why we continue to maintain that the standard ought to be the adherence to a code of conduct rather than purely income.
Okay. One of the issues that, again, you raise, and you've raised this previously, is to what extent do you consider the current whistleblowing framework, including the Public Interest Disclosure Act, provides sufficient protections alongside the secrecy offences, and what gaps still remain that you think need to be addressed? So
we, as I said, we think, and we've made other submissions to the whistleblower, amendments. We think that the bill that was withdrawn was inappropriate. We want to see an independent whistleblower protection authority. We want to see. I'm sorry, forgive me. I don't have.
No, that's fine.
I don't have the submission at the top of my mind. But we believe that the amendments. We need to see strengthening whistleblower protections. Mm-hmm. We need to see an independent whistleblower protection authority. We need to see a more robust freedom of information regime. And we need to see, and in our view, a Media Freedom Act that provides the kind of legal top cover that allows the opportunity to argue for the public interest in publishing journalism at every stage of the process are key features of what we need to have. Our point, I guess, if there is an overriding principle, it's recognising that the law already establishes a public interest in protecting sensitive information.
Yes.
Our argument is that there is also a public interest that is not recognised in law that needs to be in the work that journalists produce. We're not saying that journalism always needs to be privileged over everything else, but there needs to be an opportunity to balance or weigh up those two competing public interests. The public interest in publishing will not always win out. There'll be many times when the public interest in protecting information, sensitive information, will outweigh. But we are arguing for an opportunity to have that argument in court.
Senator Cash, I'm just checking if you're in a position to conclude your question.
Oh, sorry, I thought we had till 9:45. Apologies.
Yeah, I've just got a short
Oh, sorry, absolutely. So, no, understood. No, and that's why I said wind me up when you need to, Chair.
No, it's good.
Thank you very much for the evidence that both of you have given today. We obviously have a copy of your opening statement. What I might do, Chair, can we put some questions on notice through the official committee process? So if you both, I will put further questions on notice. Thank you very much, Chair.
Thank you. And in the time that we've got left, in your submission, you talk about being happy to see some major amendments to the bill that will better protect the rights of journalists. And I feel like you've unpacked some of the things with Senator Cash this morning about where you think some of the challenges are. I'm just wondering if you can step us through where you think the benefits are of the bill for protecting the rights of journalists.
Yeah, absolutely. I mean, and again, I'm going to invite Michael to step in here, but very briefly, as we're very happy, we're happy that, let me just go back. We are very happy that the deemed harm offences has been removed. We're very happy that secret or top secret no longer is no longer the kind of parameters for deciding. We always argued that was arbitrary, that it was decided by through the protective security policy framework rather than through legislation. So it was often very difficult for journalists to be across those kinds of changes, but also equally, as we've seen, as was evident in the Afghan files case, that sometimes classified information carries information that is marked as classified or secret or top secret still carries information that is genuinely in the public interest and may not necessarily be damaging to national security. And so our argument is that by focusing on the damage done rather than on merely the classification is the right way to go when it comes to deciding where these boundaries should lie. We think that the meaning of the terms that we are happy to see the terms inherently harmful information being repealed. We think that's a good step forward. And we're also pleased to see the public interest defence for journalists. We still think, and I want to emphasise this, that the reverse onus of proof for journalists remains a problem. We think that upends the presumption of innocence, and although the explanatory memorandum said that it's easier for the defendant to make the case, we still believe that that's not an appropriate, not sufficient reason to upend that principle. Michael, do you have anything to add?
Yeah, look, yes. While we think that this bill could be improved and should be improved and would, if passed, still leave things unbalanced, if it is passed in its current form, it will bring a sea change, and we would want to acknowledge that, because it would be the first time since 9/11 that a step has been taken in the other direction, and the signal that will send to the media and the public is a powerful one. That the Parliament has recognised that things have been unbalanced for a long time, and that there is a need to wind that back and honour the principle of press freedom to an extent that has slipped a long way. We think that certainly deserves a lot of credit and applause. We'd far rather see this bill pass in its present form than not at all. But yes, we still think there are significant improvements that could be made.
Yeah, absolutely. And just on something that you said, Professor, I'm wondering if you can expand on why the inherently harmful information is a really important change for journalists. Let me check my notes.
Let me just go back to make sure. Look, we always felt that those terms were too broad and too vague. And as Michael said earlier, one of the problems, there are two parts of this problem. Obviously, there is the question of prosecution, but there is also, that vagueness also places a degree of risk that has a chilling effect on whistleblowers coming forward. Clarity makes things easier and better for everybody, and we think that that term inherently harmful is too vague and too difficult to understand and interpret and apply. And so we think that it has a chilling effect on the work on potential whistleblowers in journalism, and so we're
Yeah, can I just add? One of the principles that underpin our submissions all through has been that the criminal law must have certainty. People must be able to know. They must be able to read the law and understand if what they're going to do is a crime or not. And when you have subjective deeming provisions, language like inherently harmful in a criminal law, it's impossible for people to know, if I do this, am I going to be committing a crime which could put me in prison for 5 years? That is bad law, and the criminal law must deliver certainty to everyone, because we're all subject to it.
And so taking this out achieves some of that.
yes.
Yeah, it's a big step in that direction, but there are still some parts there that leave that degrees of that uncertainty in place.
Were you going to say something in addition to that?
No, I think Michael's pretty much nailed it.
Excellent. And I'm just wondering if you wanted to talk a little bit more about the secret and top secret parts too, because it sounds like that's a really important change for journalists as well.
Again, Michael, do you want to speak to this?
Sure. Yeah, look, I mean, that was probably the most problematic, or one of the most problematic aspects of the law as it was, because the classification is an act of the executive. Bureaucrats making those types of decisions about whether any particular information or document is classified or not, subject to internal government policy. There was a fundamental legal problem with that, in that nobody could possibly work out which policy was in effect at which moment in time to determine, whether something was, whether that classification was in place or not. And from the perspective of journalists or whistleblowers, of course, it would be absolutely impossible for them to know whether what they were going to do was going to constitute an offence. But the really fundamental problem there is of course, the self-serving problem of government being tempted to whack classifications on its own secrets to prevent them from ever seeing the light of day. And of course, that is the most anti-democratic thing you could possibly do. So yes, it was dreadful law, and we're really glad to see it go.
There's also an inherent incentive to overclassify rather than underclassify. A public servant is far more likely to get into serious trouble by underclassifying than they are by overclassifying. I mean, by way of example, I remember when the PJCIS held its inquiry after the AFP raids, the ASIO submission was classified. Now, I have my cousin, senior ASIO officer at the time, I called him and said, "You've got to be kidding," and it was declassified literally minutes later. But the instinct for ASIO is simply because it comes out of ASIO to mark it as classified, and that was exactly what happened with that document. It wasn't there was necessarily anything in it that was sensitive. It's just that it came out of ASIO. But that was and should have been a public document for a public inquiry. And if ASIO had other things that they wanted to say, well, they could have said it in camera. But that's an example of the kind of instinctive classification which gets in the way of the kind of transparency that we're talking about.
And this change removes that.
Yes.
Yeah.
And that is why we're very pleased to see that.
Excellent. All right, I might leave the questions there unless you've got. I thought you might have one final.
No, just very briefly, and I know then we literally are at time.
Yeah.
There are two bills dealing with the secrecy provisions. The first is the sunsetting bill. Very simple bill, just extends the sunset out until December. The second is this bill, the more substantive bill. We'll obviously pass the sunset, which gives us then that 6 months that we can really, if we need to, work on this bill. Do you see that we need to take the time to really get this bill right?
I'm going to let Michael weigh in on this, but just again, very quickly, my view, I think it's more important that we get it right than we get it fast.
Yeah. And we'll have that time because we will extend out the sunset.
Yes. Yeah, I mean, I don't see any reason for haste with this. I think it's more important that we have these discussions and we get it right. Michael?
Thank you, Professor.
Yeah, I agree completely. Yep.
Thank you, Mr. Bradley.
Well, thank you so much for giving up your time this morning to come and speak with the committee. I don't think you've been asked to provide any additional information, but Senator Cash has indicated that there will be questions on notice
which
for
we'll get
you.
to the Secretariat.
I'm not sure. I think that is the Thursday, 11th of June, that questions on notice will be required to be responded by, and you'll also be sent a copy of the transcript of your evidence and have an opportunity to request corrections to any transcription errors. Thank you so much for your time. Really
Thank you
appreciate
very
it.
much, Senator.
Thank you very much.
I now welcome our next guests who are joining us online from Australia's Right to Know. And before I do that, I also note that we have an additional late submission that has been received from the CDPP, unless there's any objections to this document being tabled. Yeah. And also from Australia's Right to Know. Thank you very much, committee members. To our witnesses, thank you very much. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For our witnesses from the ABC and SBS, I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, we might do a little around the room and get you to state your full name and the capacity in which you appear. Oh, there we are on the screen too. Sorry, the screen's doing a bit of a dance at the moment, like appearing and then, anyway. Oh, okay. You keep jumping around.
If we leave that like that, yes.
Yeah, if we can just leave it like that, that would be great. Yep. Sorry. Slight technical challenge on our end, but we might hand over to you, and if you can do an around the room and say full name and the capacity in which you appear, please.
Great, thank you very much. My name's Bridget Clare. I'm the Chief Executive Officer of Free TV Australia.
Michael Kernan, Director of Public Policy at Free TV Australia.
Lynn Kemmis, I'm a Senior Legal Counsel at SBS.
Jason Shea, I'm the Head of Regulatory and Commercial Law at the ABC.
And I'm Robert Todd. I'm a Senior Consultant here at Ashurst Australia and Legal Advisor to Australia's Right to Know. I should indicate to the committee present in the room but not appearing as a witness and can leave the room if necessary is Jason Strawn, who's also a legal advisor.
Excellent. Thank you very much. Would you like to make a opening statement?
Yes, we would. Thank you very much and good morning to Chair and committee members, and apologies we can't be with you in person this morning. Thank you very much for the opportunity to appear on behalf of the Australia's Right to Know Coalition. Tomorrow, as you're no doubt aware, marks exactly 7 years since the AFP raided the home of then News Corp journalist Annika Smethurst. The very next day, the AFP raided the Sydney headquarters of the ABC. Those raids, targeting two entirely different public interest matters, sent shockwaves through the Australian media, the rule of law and our democracy. They put a very harsh spotlight on an undeniable truth. Australia's secrecy laws had become a direct threat to transparency and the vital role of the fourth estate. Ever since those events in June 2019, ARTK has sought a comprehensive review of these laws with a simple, fundamental principle in mind. Journalists should not face the risk of going to jail for simply doing their jobs. We engaged fully and constructively with the review processes that followed. The Government's Attorney-General's Department undertook a review of Commonwealth secrecy laws in 2023. The Independent National Security Legislation Monitor, or INSLM, conducted a thorough review of Part 5.6 of the Criminal Code in 2024. ARTK made exhaustive forensic submissions to both reviews, championing principles of open government and free speech. The bill is presented as the legislative output said to embody the government's response to those reviews. While the bill acknowledges the need to better protect journalistic freedom and makes a number of welcome improvements based on previous submissions, it remains seriously wanting in a number of important respects. As a result, the bill does not effectively support the needs of a well-functioning democracy where journalists can, in the public interest, hold power to account. In many ways, it introduces further complexity and impediments to public interest journalism into our legal system. Instead of streamlining a broken system without further amendment, this bill leaves behind a dangerous, fragmented legal landscape. We hold three very serious concerns with the legislation as drafted. First, the bill fails to repeal more than 520 standalone secrecy offences. While the bill removes about 29 offences, it leaves over 520 active on the Commonwealth statute book, with no clear justification. Crucially, ARTK is not aware of any of those remaining 520 plus offences containing a journalist defence. Because of extended criminal liability principles, journalists remain fully exposed to being prosecuted as accessories to insider offences when receiving information from a public sector source. A legal landscape this dense is impossible to navigate and places an unacceptable chilling effect on editorial decision-making. Second, the proposed new section 122.4 offence is fundamentally flawed and unworkable. Both the AGD and the INSLM previously concluded that criminal secrecy laws must require proof of actual or likely harm to an essential public interest. Yet, this new offence contains no harm element whatsoever. Instead, it relies on an indeterminate quasi-moral standard whether a disclosure was improper and intended to create a benefit or detriment. Intending to benefit a journalist by providing them with public interest information could see a morally blameless whistleblower jailed and a journalist prosecuted alongside them. This is likely unconstitutional, deeply uncertain, and entirely offensive to the rule of law. Third, the bill fails to correct defects in existing journalist protections. ARTK's primary position remains that the public interest journalism requires a clear exemption from all secrecy offences on the statute book. Short of that, the current journalist offence under section 122.5 subsection 6 must be recast as an exception to clearly signal that journalism is not prima facie a crime. Furthermore, the bill retains reverse evidentiary onus on the journalist, forcing a journalist to have to face a criminal hearing and then be forced to raise matters relevant to their innocence just for informing the public, completely upends the presumption of innocence. We've attached to this opening statement a table of key issues raised by ARTK in recent years and the history of consideration by the INSLM and responses by the government. table clearly sets out that these issues remain fundamentally unaddressed, despite repeated and consistent advocacy on these points by the combined media sector, often ignoring recommendations from the Insulam and the Attorney-General's Department over a number of years. An informed public is the only effective safeguard against government abuse, excess and mismanagement. If secrecy laws can still be used to prevent the public from seeing maladministration or corruption, our democratic framework risks breaking down. We urge this committee to remove the new section 122.4 offence, to expand consistent journalist protections across the entire statute book in the form of an exemption rather than a defence, and a return to genuinely harms-based approach to secrecy law reform. We note that we're joined by representatives of ABC and SBS today. They are members of ARTK and support the positions outlined in this statement and the ARTK submission. However, there's a number of issues specific to ABC and SBS that they wish to briefly raise in conjunction with this opening statement, and I invite them to do so now. And once we've heard from them, we very much welcome your questions.
Yeah, thank you.
The ABC and SBS thanks the committee for providing us the opportunity to attend this hearing today. We support the issues raised by our colleagues in the opening statement you've just heard and the submissions made by the ARTK regarding important measures required to protect public interest journalism. As members of the ARTK, our position is consistent with those already put forward by the ARTK. We are keen to ensure that protections applying to journalists are extended in full to the ABC and SBS. As you'll appreciate, as Commonwealth entities, this bill raises issues for the national broadcasters that don't apply to other ARTK members. So this opening statement will focus solely on the key issue for the national broadcasters. To that end, we support the current drafting of the bill, which leaves unaltered the definition of a Commonwealth officer in Part 5.6 of the Criminal Code and includes a new definition of a Part 5.6 Commonwealth entity, which explicitly excludes the officers and employees of the ABC and SBS. We also support the proposed amendments in the bill to existing Part 5.6 secrecy offences to reference Commonwealth officer and Part 5.6 Commonwealth entity to ensure those offences do not prevent our employees from conducting important public interest journalism. Finally, as set out in the ARTK submission of 14 May, we support the recommendation in that submission that these amendments are applied retrospectively so that it is clear the offences were never intended to have applied to public interest journalism of the ABC and SBS. We thank you for providing this opportunity today.
Thank you very much. We'll proceed to questions now and go to Senator Cash.
Thank you very much, Chair. Thank you both for your opening submissions. In the first instance, can I turn to Schedule 3 of the proposed bill? Because I note that you made submissions to previous inquiries and also to this inquiry, but Schedule 3 doesn't really appear to have been touched upon. So I just want to confirm, what is your position on Schedule 3? In particular, you have the Porter direction, which was made at the time of the Annika Smethurst event. That is, the consent of the Attorney-General is required in relation to certain secrecy offences. This now takes that schedule way further. It embeds it in legislation, but actually means consent has to be acquired or is required before any prosecution for a secrecy offence can be commenced. Can I ask, what is your view on that?
Thank you, Senator. And you're quite right about it's not addressed in our submissions, although in the table that we've provided...
It does have, no, there's a very small part of it, and it doesn't necessarily address Schedule 3 exactly, because there's a fundamental difference between the Porter direction, which currently sits there as a live instrument, and embedding something in legislation and taking it way further.
I understand that, Senator. The position is this, that we say that we welcome the provision It's better than having nothing, if we could put it that way, and I don't put that tendentiously. But in effect, what that does is closes the barn door after the horse is bolted to an extent, because what it doesn't focus on is the actions at the start of all of this, where journalists are subject to the prospect of being charged, making editorial decisions about a particular story in public interest. They get the benefit if they get to the point where the Attorney General has to consent, but it doesn't prevent the steps all before that. So the chilling effect is not overcome by this particular provision. And I note also that if you look at subsection 2 of the proposed provision, it says the various things that could still occur before the consent is obtained, which is including someone may be arrested, the journalist can be arrested, a warrant for arrest can be issued, a person may be charged with an offence, and a person can even be remanded in custody or on bail. So there's still that threat that hangs over the head of the journalist, notwithstanding that provision, and we do welcome having a provision at least of that sort. Our concern, of course, is to have proper protections for journalists that impact at the point of decision-making, where they have to decide whether to publish a story in the public interest, and having certainty about what their position is before they do that.
Thank you for those comments. You say you welcome the provision, and then obviously you still have the serious concerns with the bill, and you've articulated them in particular in your opening statement. The concern that I have is one that you've articulated. So, for example, if you were looking at prosecuting for a crime against humanity, the consent is actually required at the beginning of the process before the police can actually go out and undertake the charging, etc. And so I think absolutely you've raised a very relevant issue there. It's a live issue, and I think it does leave a journalist hanging because there's no time period in which the Attorney General's consent has to be given. But if I step away from that when you say you welcome the provision, if we are dealing with the bill as is, and we had to make a decision on the bill as is, in other words, if we accept Schedule 3 as is, it goes through warts and all without actually tackling anything else that you've raised, what does your position become then?
Well, I think our position is that we don't think the bill should be passed in its current form, and that there's a lot further that needs to be passed to improve the deficiencies that we've identified in our submissions.
Yep, no, and I just wanted to clarify that, because when you welcome a provision in isolation, that's exactly right. There is a broader picture here that does need to be looked at. One of the issues that you raise in your submission is in relation to the new section 122.4 offence. Can you take me through why you say it needs to be removed? And do you believe that section 142.21 actually already covers that conduct?
Sorry, Senator, the section again?
The 122.4.
And 1.2.
Yeah, it's your second point in your submission that we do actually have in front of us. Thank you very much. So the proposed section 122.4 offence is fundamentally flawed and unworkable. Perhaps take us through why it's fundamentally flawed and unworkable, but in particular, again, if we're just looking at this bill, what you need us to do to actually address your concerns.
Well, the fundamental problem with 122.4, and we say it should be removed from the bill entirely, is that it's indeterminate by the nature of the wording used in it. It lacks any harm element that's been identified, which universally has been agreed across all the inquiries is a relevant thing to have for these sorts of security provisions. And we also say it is likely to be unconstitutional because of the lack of identification of a relevant harm element. So the secrecy offences, we say, should only target disclosures of government information where they have some form of clear harm or is likely to result from a disclosure. Now, 122.4 doesn't do that. The harm is clearly definable to a public interest. And again, 122.4 doesn't do that. And it's of a gravity that warrants a criminal sanction. Now, just saying that something is improper doesn't identify a harm or what the gravity of that impropriety is. So it leaves open a much wider spectrum of possible action than is currently contained in the statutes. And if you look, for example, at 142.1, some of the actions in relation to the revelation of confidential material might be captured by that in circumstances. And we say that a number of the existing provisions would capture conduct that we apprehend might be considered to be worthy of criminalisation.
Can I say, I just find the point you make, rear clear harm, and I say this is a theme throughout the submissions, so it's certainly not yours alone. It is something I think that does need to be addressed because it is raised so often. But the constitutionality, can you just take me through why you say it may be unconstitutional?
Yes, because there's sort of two elements to establishing the constitutional and private freedom defence. In other words, speaking about political matters. The first is that it burdens the speech. There is no doubt that the law relating to disclosures of this type would burden speech. I think that would be readily acceptable. The question then arises is whether it's reasonably adapted to the circumstances, the legislation is reasonably adapted to the circumstances it's addressing. And here, it doesn't do that because the circumstances it's addressing is security and government information. But we've had a whole range of inquiries that have identified that you should clearly identify the harm before you legislate on that topic. And indeed, those interests along the way in those inquiries have been identified as national security, defence, international relations, law enforcement, public safety. But when you look at 122.4, it doesn't identify any of those harms. So it can't be reasonably adapted. Because it doesn't go into that granularity that is required by the Constitution on these points. Now, that may be a matter for debate somewhere else, but we say that we think it suffers that flaw. And really making that point is just to reiterate our point that everyone has agreed that you should identify the harm that's being addressed so that people have certainty about what this law applies to. Is it intended to apply to a contractor who goes into a government department to do some work and identifies occupational health and safety difficulty in the particular department and decides to report that to a journalist that they think this workplace is terribly unsafe? This law surely can't be contemplated to cover that sort of disclosure as being improper, even though it might confer some benefit on the journalist in a sense to publish that. So we think it's just too broad and it's not really grappling with the real issue here, which is, and we accept there are some things that might attract criminalisation of this type, and that our journalists should be clearly understanding what they can and can't do in informing the public about important matters of public interest.
No, and thank you. That is actually very good evidence that you've given, so I really do appreciate that. Just one follow-up question on what I had previously asked in relation to the position on the bill as is. If it was currently drafted, we made no changes to it. Your position is you'd prefer it not to go through. I don't know if you had the benefit of hearing the previous witness, Professor Peter Grest. Their position, and they're the Alliance for Journalist Freedom, actually was the opposite. And they said that they would prefer this passed as is, as opposed to not passing at all. So can I just understand, and I think you probably articulated it, in fact, in just in the most recent conversation. For you, though, there is actually more downside in this passing because, in particular, the constitutionality, the lack of direction, etc., the issues with Schedule 3 that we do need to work through, than it going through.
Yeah, there are clearly elements of the bill that we support, and that's set out on the table. But
yes.
Perhaps I can just give you the specific areas that, in overview, we support. We certainly support the removal of the security classification markings.
Yes. Of that number of offences, are you satisfied that that's enough offences? There are obviously some remaining.
We're certainly not satisfied that the bill deals with 520 or so offences that will remain on the statute book and cause a problem for our journalists to deal with, and editorially a problem. That's really a big issue of ours.
Okay.
And linked to that, of course, is that whilst there is the what I'll call the journalist offence in Part 5.6, it doesn't extend to any of those offences. So we have the difficult position that you might be charged under one of those 520 and under Part 5.6, have a defence for one but not the other. That's a real problem.
Yes, okay, thank you.
So we do support the removal of security classification. We have identified, we're a little concerned about some statements in the explanatory memorandum which seem to suggest by stealth they are coming back in because they can be relied on in proceedings to define what is improper. Now, that might have been unintentional, but that should certainly be clarified. We say that doesn't legally work. We support the removal of the dealing with offence. We support the repeal of the proper place of custody offences in section 122.1. We support, and you've heard from the ABC and SBS, their exclusion from the insider offences in 122.1. And we've dealt with it already. We certainly support the extension of the Attorney General's consent, but with the qualifications I've identified previously.
Thank you for that. I've got two questions. One actually just flows on directly from what you have just articulated. One of the other issues raised by the previous witness and in other submissions in relation to Schedule 3 and the Attorney General's consent, does it actually cause a tension between a journalist wanting to be someone who reports freely, fairly, impartially on the government of the day, and then one who understands if I do that, it is actually a politician sitting in judgment of me, and so therefore I may tone down my reporting in order to curry favour. How do you actually straddle that tension? Because the previous witness was quite adamant that the role of the Attorney General has changed over time, and today it's more a political role than perhaps in the past, the true first law officer of the land.
I think the answer to that is that we would prefer to have the legislation amended in a primary sense, dealing with the primary sections, so that we don't get to the point where a politician is put, to put it this way, in the difficult position of having to decide to provide consent. And that will be as you can see from that section, at a point where there's been a lot of effort usually expended, as was the case in the Smethurst case, by authorities in a particular direction. So it makes it a very difficult place for a politician who has been appointed Attorney General to make that decision.
They're essentially being asked to excuse what's already been characterised as criminal conduct. And what we'd like to see is that the thing was not characterised as criminal conduct from the outset. All of our submissions for the past 7 years have been aimed at achieving that one thing, which is that people should be able to prepare these stories and know that they're able to report in the public interest within defined parameters. Obviously, there's going to be areas where, you know, there will be reporting that is not permitted, but they need to have certainty at the time that they decide to do those stories, not sort of do it and then hope that a friendly politician who might be getting a lot of pressure placed on them from an alternative direction excuses it down the track.
And the clearest way to achieve that is to exempt them from the provisions rather than have them go through a defence process or that consent process as we suggested in our opening statement.
And Senator, your own comments about there not being a time frame really does mean a lot of damage can be done to public interest journalism. And I do wonder, even if the journalist becomes exempt, if the police were to, for instance, identify sources, whether those sources might be subject to criminal offences based on an investigation done, which is ultimately not consented to by the attorney.
Yeah, no, they're all very good points. One other question. The explanatory memorandum itself provides protection to people acting in a, and I quote, professional journalistic capacity. We're in 2026. Can you define the journalists or media organisations who should be covered by the defence? And in particular, does it include the online independent media, including blog and Substack writers, YouTube channels, etc., particularly where those people do derive an income from that activity?
Senator, we think that the current wording in subsection 6 of 122.5 is probably adequate to cover the sorts of things that you've just addressed, because it deals with the activity the person is engaged in at the time of the publication. I might note that this has not been addressed in any of the various inquiries on this point. And one can always improve laws, but that seems, we actually seek to have that extended across the statute.
Okay, yes.
We think that provides a greater benefit to all of those engaged in the business of reporting news and presenting current affairs, as you'll see there in the section. That's how that's referred to.
Okay, so you're the subsection 6, you're happy with that one? Yep.
Yeah, we think that should be extended across the statute.
But extended across, exactly, yep, okay. Thank you for that.
Excellent. Thank you, Senator Cash. Senator Polley.
Thank you, Chair. I just have a couple of questions, but firstly, thank you very much for your submission and making yourselves available this morning. The bill excludes ABC and SBS staff from secrecy offences that apply to the Commonwealth officials. Can you expand on how this change assists the work of your organisation?
Yeah, really what it seeks to do is it seeks to treat the staff of the ABC and SBS as members of the media rather than as members of the public service or as public officials. And so it really does remove that risk to us as what we would have been Commonwealth officers or Commonwealth entities from being found to have committed an offence if we weren't doing so in pursuit of public interest journalism. So it just creates that sort of separation from us as a Commonwealth entity who might be holding information, sensitive government information, for instance, and it sort of treats us in a slightly separate category as an entity that doesn't naturally hold that information, but may seek to want to raise important issues in the public interest.
Thank you for that. It was mentioned in the opening statement, but the bill repeals over 300 secrecy offences across the statute book. How does this support the work of your organisations?
The reduction in offences makes it simpler for us to determine what we can and can't report. I think there is still a challenge here for us, though, in that because there are so many offences that do exist in the statute book, it is a challenging thing for entities like the ABC and the SPS to determine what can and can't be reported. And it's not so much, I think, that we wouldn't end up reporting something if it were in the public interest. It's more that it might take us quite a bit of time to work out what we can and can't do. And that might sort of reduce the amount of public interest reporting that we can achieve in the time that we have.
Yeah, I'd just add to that, the reduction is good, but as noted in the submissions, the criminalisation remains a really important factor to look at. So, it's not just reduction overall, it's where the consequences of disclosure could be criminalised. I think that's where we're asking for some attention as well.
Thank you. Thank you, Chair.
Oh, sorry.
A number of offences, yes, that are remaining well over what seems to be reasonable in the circumstances. So, there's still 520 secrecy offences that journalists have to navigate their way through in media organisations in order to decide whether they're able to publish stories, whether they're ABC, SBS or others.
Including because we're unaware of whether the journalist defence exists, applies to those.
And that also exists in Part 5.6. I note, for instance, with the extension of the sunsetting provisions, that there will still be some offences in Part 5.6 which would potentially apply to the ABC and SBS.
Thank you. Thanks, Chair.
Thank you, Senator Polly. That concludes the questions that we have for you this morning. Thank you very much for giving up your time.
I will chair, just with the previous witness, if I may place some questions on notice to you.
Yeah.
Thank you very
Absolutely.
much. Thank you.
Absolutely. Senator Cash has foreshadowed that there will be some questions coming your way on notice, answer to those questions, if you could please provide that to the Secretary by the 11th of June. And as is usual practice, you'll be provided a copy of the transcript of your evidence, and you'll have an opportunity to request corrections to any transcription errors. Thank you very much.
Thank you.
Now welcome representatives from the Law Council of Australia, the Human Rights Law Centre and the Australian Human Rights Commission. Come on up. We will get people to introduce themselves. Yeah. Excellent. I understand that information on parliamentary privilege and the protection of witnesses' evidence has been provided to you and is available also from the Secretariat. For the Hansard record, I'll get each of you to state your full name and the capacity in which you appear, and then we can proceed to some opening statements. I might start with those in the room first, and then we'll proceed to people online.
Thanks, Chair. Mr. Kieran Pender, Associate Legal Director, Human Rights Law Centre.
Thank you, Chair. Alana Barbaro, lawyer at the Human Rights Law Centre.
Excellent. And we'll go to the Australian Human Rights Commission.
Good morning, Anna Cody, Sex Discrimination Commissioner.
Thank you.
Good morning, Louisa Wong, Senior Lawyer with the Australian Human Rights Commission.
Excellent. Law Council of Australia.
Good morning, I'm Associate Professor Rebecca Ananian Welsh, and I'm representing the Law Council of Australia. I believe there are others just logging on.
Excellent. Excellent. You've joined at the perfect time, Mr. Mason, to introduce yourself. Although your camera, not quite sure we can see you on the camera there. Yep, excellent.
Thank you very much. It's, Ben Mason, lawyer at Moran Agnew and chair of the ACT Public Law Advisory Committee.
Excellent. And do we have Mr. McDonald and Dr. Andrews who will be joining us? We are running a little bit ahead of time, so that's completely fine if they join us during some opening statements.
I'm told they are logging on.
Yeah, that's okay. We might get to some opening statements, and I'm sure they'll probably be with us by the time we are concluded there.
Thanks.
It's worth just noting before we go to opening statements that members of the Australian Human Rights Commission are only available to 11 a.m. as well. So, yeah, we might just, if we've got some questions, direct them there first. All right. Do you have an opening statement?
We do. Thank you, Chair. We thank the committee for the invitation to appear today. My colleague Kieran and I are lawyers in the Human Rights Law Centre's Whistleblower Project, Australia's first specialist legal service for whistleblowers across Australia. Since launching in mid-2023, we have triaged over 700 whistleblowers, advised over 220 and represented over 60 on an ongoing basis. We advise and act for clients under Commonwealth Public Interest Disclosure, or PID laws. This often requires us to advise on the potential application of secrecy offences in Part 5.6 of the Criminal Code. These unbalanced and overbearing secrecy laws undermine government accountability and risk punishing public interest whistleblowers. We have seen them have a chilling effect on whistleblowers who want to expose serious wrongdoing in government. Transparency and accountability are crucial to Australia's governance and security. This bill moves us towards a more balanced secrecy regime that recognises that fact. We commend the Albanese government for moving forward with this critical reform. This is landmark transparency reform for which the government deserves much credit. However, this reform should address the heavy-handedness and the uncertainty that we see in the current secrecy regime as far as possible. To that end, our submission to the committee makes several recommendations. A primary concern of ours is the proposed section 122.4. We consider it is uncertain and does not create a balanced harm-based offence. Secrecy offences should only criminalise conduct where there is a genuine need to do so. As the Insulam and Attorney General's Department recommended, that need only arises where conduct causes harm or serious damage to public interests. Currently, the proposed offence criminalises a far broader scope of conduct. It may criminalise civil society and voluntary engagement with government, and it will detriment our clients and our work. Our work has also demonstrated to us a compelling need for a general public interest defence to these offences. Our clients often hold valid concerns about wrongdoing and want to disclose or have already disclosed information to stop it. Often their action benefits us all by leading to detection or prevention of corrupt, unlawful or unethical conduct. And one might assume that these whistleblowers have a clear pathway under PID laws to disclose that information safely. In our experience, that is often not the case. We have regularly raised concerns with the Commonwealth's PID Act. It is unfit for purpose, difficult to navigate and outdated. We routinely see whistleblowers who are not covered by the scheme or have not satisfied the scheme's preconditions, often inadvertently. People who blow the whistle in the public interest but have not complied with the PID framework should not be exposed to criminal liability. Even if and when PID Act reform is completed, that need for a public interest defence as a last resort will not fall away. Lastly, secrecy offences and PID laws inform each other. If PID laws don't provide accessible, clear pathways for whistleblowing, overbearing secrecy offences are especially harmful. Failing to address the flawed PID Act alongside this bill does whistleblowers a disservice and limits this bill's ability to protect the public interest and good governance. We consider that reform to the PID Act is needed alongside this bill. Thank you.
Thank you. Commissioner Cody, have you got an opening statement?
Thank you, Chair. Yes, I do. And thank you for the invitation to provide evidence today. The Commission supports the repeal of Section 92 of the Sex Discrimination Act, which was the focus of the Commission's submission to the Committee on the Secrecy Provisions Amendment Repealing Offences Bill 2026. Repealing Section 92 of the Sex Discrimination Act is an important reform, as there's no justification for its ongoing existence. Under Section 92, if a complaint alleging sexual harassment is lodged with the Commission, it's an offence for any person to disclose any particulars of that complaint until an inquiry has commenced or the complaint is withdrawn or terminated. And this applies with limited exceptions to the complainant, the respondent and officers of the Commission. This secrecy provision was included in the 1984 Sex Discrimination Act when it was enacted to protect the reputation of respondents from potentially unjustified or malicious complaints. That type of justification for a secrecy provision is out of step with current thinking about the nature of sexual harassment. It draws on the myth that complainants make up sexual harassment complaints or set up complaints to smear people. Section 92 is also inconsistent with the rest of the Sex Discrimination Act, as it only applies to sexual harassment complaints and not to any other kind of complaint under the same Act. There are also no equivalent provisions in other federal discrimination acts. The Commission acknowledges that confidentiality is an essential part of complaints, but we do not consider that Section 92 is necessary for this purpose. The Sex Discrimination Act contains other provisions that better preserve confidentiality when necessary. For example, Section 112 of the Sex Discrimination Act makes it an offence for Commission staff and statutory office holders to divulge information that they acquired because of their employment or their office at the Commission. And under Section 14 of the Australian Human Rights Commission Act, the Commission can give directions prohibiting disclosure of a person's identity or publication of certain material. Finally, as a general observation on secrecy provisions in the Australian Human Rights Commission Act and Federal Anti-Discrimination Acts, the Commission notes that all 5 federal acts contain secrecy provisions similar to Section 112 of the Sex Discrimination Act, and the Commission considers that these provisions can be streamlined so that the secrecy provision in the Australian Human Rights Commission Act can apply across all 5 relevant pieces of legislation. Thank you.
Thank you. And who is from the Law Council of Australia going to make our opening statement?
I will, Ben Mason.
Excellent.
We welcome the opportunity to appear today in relation to the Secrecy Provisions Amendment Repealing Offences Bill 2026. The Law Council commends the Attorney-General and her portfolio for taking significant steps to repeal more than 300 existing secrecy provisions. This bill proposes a range of meaningful amendments to make secrecy offences less complex, fit for purpose and necessary. On the whole, the bill represents a substantial and welcome reform to Australia's secrecy framework. The Law Council recognises that carefully targeted secrecy offences have an important role to play in protecting Australia's national security and the integrity of information entrusted to the Commonwealth. Such laws are vital where necessary and proportionate to achieving that aim. However, secrecy laws that exceed strict necessity and proportionality, whether by design or through unclear drafting, have the potential to impose upon and undermine the rule of law and the institutional underpinnings of a democracy, such as press freedom, freedom of expression and civil society engagement. Principles of transparency and open government are also important. While we support most of the proposed reforms, some aspects of the bill would benefit from additional consideration. The new general secrecy offence that the bill proposes to insert at section 122.4 of the Criminal Code raises particular concerns for the Law Council. We are concerned that, first, the provision characterises all persons who provide unpaid services to the Commonwealth as an insider akin to a federal official. We submit that this approach is broader than strictly necessary and inappropriately risks capturing unpaid volunteers who participate in consultations with Commonwealth entities as part of Australia's routine public policy process. Second, the offence contains no definition of services. This introduces significant uncertainty concerning what activities may be characterised as services. A narrower and clearer definition will provide much needed certainty to civil society who engage regularly with the Commonwealth in a manner, again unpaid and without the clarity provided by contract, that risks being unnecessarily captured by this provision. Third, the offence as currently drafted does not attach any materiality to the type or degree of benefit and detriment conferred upon any person, creating uncertainty as to its scope. Higher thresholds are required to ensure that, for example, causing mere embarrassment to any person or to the government does not risk prosecution. And finally, the offence contains an element that it would be reasonable to conclude that the use or communication of the information is improper. We are concerned that this element does not communicate an objective standard of conduct, nor does it communicate the clear boundaries of criminal liability. The term improper is not defined in the legislation, and the Guide to Framing Commonwealth Offences expresses caution about its use in criminal offences. We suggest that the committee recommend this offence not proceed as drafted and should be further consideration should be given to an offence that is narrower in its scope, more certain in its terminology, has higher thresholds of harm, and incorporates key safeguards to ensure that a more careful balance is struck between capturing conduct which should fall within a criminal offence and that which should not. In terms of safeguards, we have concerns about the adequacy of defences found at section 122.5 to accommodate the broader application of this offence. An exception ought to be introduced that protects a larger section of civil society than journalists alone, who seek to act reasonably by making disclosures in the public interest. For example, academics, public commentators, and civil society organisations performing similar public interest functions. Again, we regard the proposed measures as generally a positive step towards reforming a framework that is long overdue. Through further refinement of the bill, in particular greater clarity on the scope and thresholds as set out in our submission, we are hopeful of a secrecy framework that is fit for purpose and consistent with expectations of transparency in government. We thank the committee for your time today, and happy to respond to your questions.
Thank you very much, and also welcome to Mr. McDonald and Dr. Andrews. We'll proceed to questions and begin with Senator Cash.
Thank you, and thank you very much for your opening statements. If in the first instance I could address some questions to the Law Council, and thank you for providing the recommendations that you did in your submission and obviously articulating them just then on the record. Can I just say then, if the bill did pass in an unamended form, given as I look to your recommendations, the significance of them, what would be the effect of the bill passing in an unamended form?
Well, I'm happy to start. I think one of the main points that we have about this bill is its uncertainty.
Yep.
The breadth of these terms that we've highlighted, meaning that it potentially captures a very wide range of conduct by a very wide range of actors. And in that initial period, of course, we don't have any interpretation of that, courts or whatever. So the first thing I think we could expect is a chilling effect where the Law Council would have to think very carefully. Law Council, for example, would think very carefully about what kind of conduct it's currently engaged in or people it represents are engaged in that may actually fall foul of the Act. And that would mean considering words like improper.
Yep.
That is very difficult to grapple with. So it would have that chilling effect. And Nathan may be able to speak about some more specifics from the Law Council perspective.
Thank you. I think just as a general observation, Senator, as Rebecca mentioned, it's hard to respond to that question because our submission really does focus on the uncertainty inherent in the general secrecy provision. And with that uncertainty is the uncertainty of how it's going to be applied and the discretion that is exercised in its application. So it's a very difficult question to answer, but in fact the answer is it's uncertain, which is why we think it ought to be refined.
Yeah. So I suppose, just talking to other witnesses, we have a period of time that we can actually work on this legislation. That's the good news. The sunset will be extended until December. There are a number of themes that flow through the submissions, but at this point in time, the issue that you raise, in particular in relation to section 122.4 and the lack of clarity and definition with the resulting uncertainty, certainly is one of them. Can I ask you then, Your submission very much is, and you've said it, section 122.4 should not proceed without amendment. In plain English, can you tell the committee, just so we have that really good understanding, sort of the specific words or phrases in the bill, if left unchanged, actually will produce a worse outcome than what is intended?
Perhaps I can address that, Senator Cash. Perhaps also I can understand the question to be what issues arise from the current drafting, and so the starting point really is to identify or the lack of evidence base perhaps around some of the subject matter that's captured, for example, volunteers.
Thank you.
There's no evidence base around that. That volunteers require coverage by a criminal offence. So that would be one thing that we would point. So it's identifying what the mischief that the proposed offence seeks to address. Criminal offences should by their nature be narrowly and clearly constructed to address the particular need, with particular identified mischief or perceived gaps. With the general secrecy offence, we have recommended refinement of the offence to ensure that its definitions are appropriately calibrated to operate as a general secrecy offence, and that includes a clear and narrow definition of services, so that membership of such a class of persons subject to possible criminal sanction is sufficiently clear and appropriately certain. Paragraph 122.41C should be amended to provide materiality thresholds for benefit and detriment, and it should be clear on the face of the legislation that political embarrassment alone or embarrassment does not constitute sufficient detriment, and should the provisions continue to be expressed in terms of whether the use or communication of information was improper in the circumstances, extensive guidance should be provided in the primary legislation about the intended meaning of the term, as well as the relevance of particular circumstances to this assessment, as it does in other provisions appearing in the Criminal Code.
That's excellent. Thank you for that. When I look at your submission, one of the issues it points to is section 72A on foreign bribery as a drafting template. That very much does give juries a structured list of factors when assessing whether conduct was improper. Is that the type of guidance that you're looking at in this particular legislation?
So I think our starting position is that the consideration of whether improper is the appropriate term at all is the starting point.
Yep.
And if that is considered to be the case, then yes, something along the lines of, but addressed to, as we said, the particular mischief that is intended to be addressed should be made clear through drafting akin to that.
One of yes.
Sorry, Senator, just to add to that, I think it's important to know there's sometimes a tendency to try to address some of these uncertainties through the explanatory memorandum.
Doesn't work.
We would like to see the primary legislation contain that guidance, just as 70.2, as you mentioned, does.
Yeah, thank you for that. And then on Schedule 3, you've described the Attorney-General consent powers as creating an unfettered discretion that could expose the Attorney-General to allegations of political bias. So in terms of Schedule 3, what do you say should actually happen to it? And perhaps I'll give you some additional guidance in terms of, again, issues that have been raised by other witnesses. The first being that, do you actually need Schedule 3? Could you just continue to have the Porter direction sit there as a direction and cover the limited number of offences? In relation to when Schedule 3 and the consent would actually kick in, does it actually do more harm than good because it kicks in after the police have laid the charges, etc., and have conducted the raids, and then there's no time period associated with in which the offence, in which the consent has to have been given, versus, say, the consent for a crime against humanity, which actually is at the very front end of the process and actually kicks off the process. So can I just get you to take me through in detail your thoughts on Schedule 3?
I can begin probably at a more general level, and I know that others from the Law Council or otherwise will get into further detail as you're interested. I think the clearest need here is robust protection for press freedom, and we've added in, because this bill implicates it, civil society as well. But focusing on journalists for a moment, the protections that you see in, for example, the defence in the secrecy offences is what's most appropriate, because it simply says this is not a crime.
Yes.
And there's notes in our submission about that being an exception rather than a defence, but that's a separate issue. The Attorney General's consent to prosecutions, to investigations, is another protection. It's certainly not a perfect one, and it wouldn't solve everything, and the defences are necessary in our submissions. But it does provide a level of protection, however that is formed. I think whether you're having that afterwards, during, clearly, I think the greater protection, the earlier it comes in, the better. There's no way you're going to avoid consent from the Attorney General being a potentially politicised or subjective protection. It's certainly weaker than an exception or a defence, but it is a protection and it does factor it into the process.
What about, though, the tension of political bias, that if this is legislated, and I'd be interested in your views as well on whether or not this indeed does need to be legislated, can it just sit as a direction which has, within reason, the same force? You still require the Port of Direction, the consent of the Attorney-General for certain secrecy offences following the Annika Smethurst event. But in particular, if the Attorney-General is required to give consent in relation to a prosecution, does this then send a message to journalists that you need to curry favour potentially with a government of the day, as opposed to, you know, reporting fairly, freely and on an impartial basis?
So first, it does potentially carry that impression. But on the other hand, it is a protection that wasn't present during the 2019 raids.
Yes.
And the experience that we've had since then shows that potentially it has been useful. Of course, we don't have all the information from behind the scenes, but we haven't seen further raids on Australian media. It being legislated, I think, is important, though. That is a more robust protection, and by being legislated, it involves Parliament and that extra degree of oversight, as opposed to putting this entirely in the form of quite a flexible document that could be changed from time to time without that additional layer of oversight.
I'd be interested to know what the additional layer of oversight is, because once it's legislated, there's no further oversight.
That it would, I guess all I'm saying is it would have to be complied with and couldn't be changed or removed as a matter of mere executive action.
Understood. No, okay, understood.
I'm just wondering, whether you've got questions for
the Australian Human Rights Commission?
Yeah, before they need to leave.
One moment, please. And
now might be a good time to ask those
thank
questions.
you for that, Chair. Dr. Cody, Schedule 3, as we're actually talking about with the Law Council, vests the consent power in the Attorney-General over the Commonwealth secrecy offences. Does the AHRC have any concerns about a political office holder being placed at the apex of decisions affecting press freedom?
Thank you, Senator. Our submission mostly focused on Section 92 and the repeal of that, but we are broadly in support of the Law Council and the Human Rights Law Centre's submissions, which recognise that while ideally it wouldn't be the Attorney-General, because it does bring in an executive arm of government into that decision, that there does need to be, without sufficiently robust protections, that it's preferable to have at least some oversight about the decision to prosecute a journalist.
So when you say sufficiently robust protections, are they currently in the legislation, or do we need to give consideration as to what they would be?
They would need to be given consideration too. There aren't sufficient protections, but I would defer to my colleagues from the Law Council and the HRLC on this point also.
Okay. As you've probably been listening to the Law Council, and again it's a theme throughout the submissions, the new offence in section 122.4 turns on whether a disclosure is improper. This, as you would have heard and you would have read in any event, is a word the bill does not define, and drops the harm-based approach that the other reviews, the Attorney General's Department review and the Insulam's review, actually recommended. In your view, is the approach taken in the bill then the right foundation for a serious criminal offence, in particular when evidence has been given that certainty is what's required when it comes to defining criminal offences?
Senator, we've made a previous submission also to that review by Insulam in 2024, recommending a harm-based approach, looking at that, limiting that.
No, okay. So that answers that. Thank you. That very much does answer the question then, and I will have a further look at that. Just in terms of the approach taken in this bill, the government hasn't implemented a general public interest defence, despite the Insulam, the ALRC and the AGD all recommending some form of harm-based approach, as we've just discussed, and you've obviously, as you said, put that on the record in a previous submission. So just in terms with the bill in its current form, is it fully compatible then with, say, Australia's human rights obligations?
I'd have to take that on notice and refresh my memory of our previous submission, but in terms of the breadth of the criminalising of the behaviour, that would be of concern, and also, as has been referred to by my colleagues from the Law Council and also will be from HRLC, around the definitions of what is actually caught by this and who is providing the services, and the concern about the catching of engagement by civil society, which, as we know, is a key part of any engagement with human rights in Australia and internationally.
Thank you. And that was actually, I was going to pursue that with the Law Council, that the new offence does apply to volunteers and unpaid advisors who provide and the services to the Commonwealth entity, but they don't actually define services anywhere in the bill. Can I just get you to expand on what the Australian Human Rights Commission thinks of that?
We're concerned about the breadth of that because of the point that I just made around that it may have that chilling effect on engagement with civil society, and the importance of that for improving policy development and outcomes, and that we know that it's an integral part of how government should do business is to engage with civil society to strengthen any approaches, policy, legislative, that they may be introducing. So, and that is an integral part of our human rights system.
One more question, if I may, Chair. Dr Cody, then, if the bill, and I'm asking this of all witnesses to sort of get a very genuine view on what we need to do to make this bill work, because I think we all agree it's a good body of work that was undertaken, and we do want to see the bill work. If the bill, therefore, was to, say, go through in its current form, what would the impact on human rights be?
The concern is that it's overbroad in terms of criminalising behaviour that shouldn't be criminalised, that it will have a chilling effect on engagement with government, and that it does give powers which in its current form are better than not having any constraints on decisions to prosecute. But in terms of freedom of the press, that is also a significant impact that it would have if it was passed in its current form.
Thank you very much, Dr Cody.
Thank you.
Thank you. That does conclude the questions that we've got for you today. If you wanted to duck off now while we...
Thank you.
Yeah, thank you very much. Senator Cash.
If I could just pick up actually where I left off with Dr. Cody. I know that you've already addressed it in part, but if we could just flesh this out a little further again. And it's in relation to the drafting and making the new offence apply to volunteers and unpaid advisors who provide the services to the Commonwealth entity, but again without defining services anywhere in the Act. That is something that you say does need to be addressed, because what are the implications if it's not, in terms of the uncertainty?
Sorry, to whom was that question?
The Law Council. Sorry, pick up where we left off. Thank you.
Sorry. Ben, did you want to...
Well, I was actually going to suggest that there's practical examples of that the Law Council might be able to provide in relation to the work that it does as a volunteer.
Thank you.
Providing information.
Could you take us through one? Because that was actually my next question.
We can offer some examples, not necessarily limited to the Law Council, but civil society generally, that we're quite regularly approached from governments or departments on requests that have confidentiality attached to it, and of course we respect that. But we also bring in volunteers from the legal profession who donate their time to help us engage in those consultations. It's unclear at the moment whether that would be considered providing a service under the bill.
Right.
Those sort of ad hoc requests of civil society that are brought in, often at short notice with very challenging timeframes, where the term confidential is thrown around. Whether that's intended to be capturing material subject to this bill, it's unclear. And I think the point of our submission in the ambiguity around the term services is where there has been recommendations, including from the Insulum, around if you are going to be bringing in unpaid individuals to this framework, there needs to be some reference to whether it be a contractual relationship or an ongoing formality in the relationship, to really clearly define who's in and who's out when you're delineating between insiders and outsiders for this offence. So it's not an uncommon situation.
Right.
The spot check is, we have, I think, at any one time, 12 inquiries at the moment that have a level of confidentiality attached to it. So it's not uncommon that this arises.
Okay. In terms of, say, what the government has said addresses the PwC issue, how does that interact, the PwC issue, interact with this? If you wanted to capture what happened in PwC, how would you better define or write the offence?
It's a good question, Senator. I think as Mr. Mason said earlier, looking at where the mischief is probably the first start, and there's multiple references to that incident in the explanatory material. I think that was a particular incident where there was a level of formal arrangement in place.
Yes.
Not necessarily capture those ad hoc requests, particularly of civil society that might have confidentiality attached to it. So, referring to the nature of the relationship in the legislation to give some guidance about, what is providing a service, and, looking at that degree of formality, the role of the person providing the service, any contractual obligations that have been attached to that relationship as well. Others might want to join in there as well.
I could just add to that. I mean, the offence as drafted, with reference to the PwC incident, the offence would capture the business model of all consultants.
Yep.
So the person uses or communicates information. That's any information. The information was made or obtained by the person by reason of being engaged to perform work, and they obtain a benefit, any benefit, regardless of material, including financial benefit. And the work they do may well be taking information from government, packaging it up and returning it to government in a way that it's been sought. But the only thing that doesn't make this an offence is whether it's improper, and the benefit is whether that benefit is improper. And yes, there are defences, but that implies that it is an offence.
Yes.
Unless it's a defence. So
Yeah, okay.
The defence only comes in once it's a defence. So the whole consultancy model is captured here, and that would be, and not necessarily. And I think to come back to the point of the Law Council's submission is it's the uncertainty in relation to that. It's not clear sufficiently, and to the extent that it's not intended to capture certain sectors, including unpaid services, it should be excluded, clearly excluded. So it's not an offence, and we can toss the coin about what the effect of an exception or exclusion and a defence might be from an evidentiary point of view. But it, on its face, should exclude all forms of services and support or work performed where it's not intended to be captured. But at this point, the view is that it would capture most consultancies.
So I suppose one of the issues would be the way that the offence is currently drafted in the legislation could potentially create a scenario that materially increases the chance of the prosecution of civil society organisations or other volunteers as compared to the existing law.
I'll just say this, and happy to open up to my colleagues, but it's unlikely that volunteers will be prosecuted, and that's the reality of the situation. It's unlikely that will happen, but that is not the point. The point is that there is an offence on the statute book that potentially captures this.
Yes.
So, the reality, and I think everyone would agree that certainty is desirable, particularly in relation to serious criminal offences.
One of the other issues that has been raised is in terms of when the bill eventually does pass, it commences the day after royal assent with no transition period, and I understand applies to information already in people's possession. So does the Law Council say this meets the basic rule of law principles about laws being clear, prospective and knowable in advance?
Sure. Thank you, Senator. We're concerned that while offences would be prospective in application, that this imposes quite significant burdens on civil society organisations should they be captured under the existing definition of services. With 24 hours notice, employment regimes to protect the information that's already in their possession, and to give notice to related parties in to use the Law Council as an example, our constituent bodies, our volunteer members of advisory committees, of potential information which they now need to apply additional consideration to the protection of. And unlike the Commonwealth and those entities that contract to the Commonwealth, an organisation such as ours doesn't have the benefit of the Protected Information Security Framework, nor do we have a range of agencies upon which we can draw for policy and technical advice about how best to protect information of this kind. Our concern is that those transitional provisions impose significant burdens on affected parties that are magnified by the uncertainty attached to who those parties may be.
It's a really good answer, actually, and I have to say that actually it is of concern because you're the Law Council. You do know about this for very obvious reasons. What about people who quite genuinely do not follow the parliamentary process, may, as you say, be in possession of information which they don't intend on doing anything bad with, but suddenly they fall within the new section? How do you see those people being communicated with by the government and in a very short period of time, like the next day?
Well, it might be a question that's put to the department later today, Senator, about how they would intend to go about that communication.
Well, How about I phrase it differently? What is the better way to do this to ensure that a change in the law of this significance is properly communicated so that people are able to put in place the appropriate protections?
Well, subject to other thoughts, I would have thought it's a question of providing adequate guidance material and education for civil society, but also allowing a transition period that's sufficient to organisations that are able to make sure that they're compliant before the provisions are enacted. I welcome that Human Rights Law Centre may have a view as a community legal centre with finite resources. They might also have perspectives on that.
Thank you. More than happy for you to jump in.
Sorry, I might just add that the clearer the offence is and the more confined it is to the mischief, to this, I mean, this is a criminal offence, it's targeting real wrongdoing.
Yes.
Then the less the need, the less the breadth of what has to be communicated to these organisations that have the information. So if you have a formal arrangement with the Commonwealth to use information in a certain way, then continuing to use information in that way is going to be okay unless the Commonwealth communicates change in that. The current forming of this offence is so broad that in that 24-hour period, suddenly anything that it would be reasonable to conclude would be improper. You're captured by an offence you weren't captured by before, and there's criminal liability for improper use without any guidance whatsoever on what improper use means. It's a compounding of that uncertainty. And it would be quite hard to communicate to all the volunteer organisations with any form of Commonwealth information in a formal or informal arrangement over that information. Make sure you don't use this improperly, but we can't tell you with any detail what that means. And if you do, you may face criminal prosecution.
Yeah. Thank you, Mr. Pender.
Senator, we share those concerns. The application of the savings and transitional provisions we don't think have been adequately dealt with. We and the Law Council have also raised, in addition to the general secrecy offence issue, there's also some savings provisions that ensure that some offence provisions remain in force even though they've been repealed. We think that is very contrary to rule of law and good legislative drafting. So criminal conduct will remain even though on the statute book provisions have been repealed.
How does that work?
Through the operation of saving provisions that continue criminal liability in relation to what is otherwise a repealed offence.
So can you take me through that? So we repeal the offence, so going forward it's not offence, but are you saying if I currently fell within it, but it hasn't yet been discovered, it would become an offence? I'm happy for you to take it on notice.
I'll just take you to the relevant provision of our submission if you have that.
Thank you.
For us. It's on our paragraph 3.1.3 of our submission, which is on page 10 at the bottom.
Can you read that out, if that's all right?
Sure. So the effect of the saving provision in the bill at item 2.3 is that the former general secrecy offence, the lowest level, at 1.2.4, will continue to apply for provisions in 8 specified acts. Without the effect of the saving provisions preserving the old criminal code only in relation to those provisions, that criminal liability would otherwise be removed. And so we say in our submission that that's an unsatisfactory and unclear drafting mechanism which criminalises conduct via an otherwise repealed law and only signposts that liability through a note rather than a provision.
Understood.
And the Law Council at page 26 of their submission have also raised concerns about that. In relation to your concern generally about the transition of these provisions, I think one of the reasons that's so problematic is because of the uncertainty that attaches to confidentiality in informal engagement. So the Human Rights Law Centre, as with the Law Council, as with others, are often asked to consult on legislation, on policy. Sometimes that is framed as confidential. Rarely is that put in writing. Rarely are we asked, notwithstanding there has been an increase in the use of non-disclosure agreements, rarely is what is purveyed as a confidential consultation come with paperwork stating the significance of that. And so one of the concerns is the current drafting of this new provision is that ad hoc consultation, which is framed as confidential, could now expose us to criminal liability, and that could be in relation to retrospective meetings and consultations. Now, one of the concerns with secrecy provisions generally that apply to third parties, so there's a strong sort of justification for secrecy in relation to Commonwealth officers. When you apply that to third parties, such as the Human Rights Law Centre, that imposes a significant compliance burden. And we've, in our prior submissions to the National Security Legislation Monitor, for example, talked about how some of these secrecy offences have required us, in the operation of our work, to get extensive legal advice from senior counsel to avoid, as a legal service for whistleblowers, we take our obligations very seriously. On our website, it says this is who we can help, this is who we can't help. We've got advice from very eminent senior counsel as to those issues. But as you say, Senator, this provision will apply not only to the Human Rights Law Centre and to the Law Council, but to a two-person charity that are not lawyers who the government may ask to consult because they have particular technical expertise. So that, I think, underscores why the general drafting of this provision is so broad. In relation to the PwC situation, I note allegedly there were confidentiality agreements in force between PwC and the government. So I guess my question is, well, why isn't remedy under contract available and considered insufficient? Or why is this provision not drafted so as to apply when there are formal arrangements of confidentiality in place, which would mean that when the Human Rights Law Centre or the Law Council is consulting on a confidential but informal basis, you don't engage that criminal liability?
So a question to you then is, if the bill did go through as is, what do you see the consequences of that being without further refinement?
I think the tension here is that much of what this bill does is good, but that lowest level, broader secrecy offence is very problematic. And that will have a chilling effect on conduct and potentially have a real impact on groups like ours engaging with government. And one of the reasons why that lowest level provision is so problematic is because of its breadth of application to people who don't otherwise have criminal secrecy obligations. So when you amend the law in relation to ASIO agents, ASIO agents have a reasonable expectation that their work is subject to confidentiality and secrecy and they need to act accordingly. When the Human Rights Law Centre engages with government, we don't automatically think in our consultation, in us appearing here today and all the prior many meetings we've had with the department, with the National Security Monitor and so on in relation to these issues, we are exposing ourselves to criminal liability if we inadvertently shared information that we'd learned in that setting with the Law Council, for example. And so I think, again, I really commend the government. This is really important work that's been done. This bill should pass with some amendments. But one of the reasons this low-lying offence is so problematic is because of its breadth and its application to third parties.
Okay, thank you. I understand Senator Shoebridge is...
Thanks.
I think I'm the chair and I share the call, but thank you, Senator Shoebridge. I'll come to you. Senator Shoebridge.
Thank you, Chair. I was just being polite and thanking Senator Cash for her courtesy and acknowledging the undeniable authority of the Chair as I do that.
Oh, that's very kind of you. Yeah, thank you.
Can I thank everyone for their engagement with the bill? I really appreciate it. But my first questions are probably to the Human Rights Law Centre. I know you've covered some of this in your opening, but the practical effects of a sort of one-size-fits-all secrecy offence across the entire public service, I mean, when you think of your current caseload of whistleblowers, what would the impact be on them?
Thank you, Senator. I think, given, can I clarify, you're talking about the proposed new offences? Yep. So in advising our clients, we would have to be considering pretty much in any circumstance where people want to blow the whistle on information that they have gained by way of any kind of engagement with government, whether that's voluntary, by paid engagement or any other arrangement, we'd have to be considering that they would be covered by these laws and that they may be exposing themselves to criminal liability and blowing the whistle.
Would that reach as far as somebody who was consulted on a government proposal without, if they're just simply consulted and they're told, actually, we'd like you to keep this private,
The breadth of the drafting of the provision, providing or having provided services, whether paid or unpaid, to a Commonwealth entity, potentially includes...
Basically answering a question could cover that.
Exactly.
Yes.
So if you're consulted, inevitably you're going to be asked about it, and they could just be roped into a secrecy provision. The act of consulting might have to silence you.
Yes.
Have you considered what kind of amendments would be needed to fix that aspect, the sort of incredible reach of it?
Both the Attorney General's Department and the Independent National Security Legislation Monitor focused on harm-based drafting for secrecy offences generally, and we don't think the current proposed amend provision adopts that approach. And so I guess that would be the starting point. Draft this in line with the guidance that the Department and the Monitor have given.
Yeah, and Ms. Barbaro, you think about the caseload, going back to the caseload, being able to advise somebody on if the defence had a harm threshold, would that give more comfort to people to be willing to speak, do you think?
Yes, I mean, I think one of the issues with the breadth of the laws at present is, and as the Law Council has flagged as well, they're very ambiguous in their application. So we would have to be considering the risk of criminal liability with pretty much any client that has government information of any sort. If there was a harm threshold, that would likely make whistleblowers more encouraged to speak up in other circumstances.
How do you think, if we also considered a public interest defence as well as a second threshold, and I assume you see them as cumulative, not binary, but have a harm threshold, but then also have a public interest defence. How would a public interest defence work in practice?
Yeah, we would see a public interest defence as a safeguard against kind of the most unjust applications of these offences. So importantly, these offences as drafted are more broad. They apply to a more broad range of people than, for example, the PIT Act, which provides protected pathways. And
so the criminal offences have broader coverage than the protective elements in the PIT Act?
Exactly, yes. And so we would consider that a public interest defence would have application, for example, in those circumstances, and it would also generally be an effective way to prevent these secrecy offences from operating unjustly where someone has disclosed information in the public interest.
Thinking hypothetically, if somebody in the tax office blew the whistle on grossly unethical practices in the tax office and their position was supported by a review by the tax office and by a unanimous report by the Senate, by the Senate committee, that might be circumstances where a public interest defence would protect someone. Just to pick a hypothetical.
Senator. So if you look at, for example, the Public Interest Disclosure Act presently provides avenues for public servants or contractors to take information to public in certain narrow circumstances, either where there's an immediate threat to health, safety or the environment, or where there's attempts to blow the whistle internally haven't worked. Those provisions are incredibly technical, and we see in our practice day on day trying to meet all of those thresholds. People sort of still don't quite comply with all of the checks and balances. So, for example, one of the components of an emergency disclosure is the extent of the information disclosed is no greater than is necessary to alert the recipient to the substantial and imminent danger. So you've got a whistleblower in a situation of immense stress, trying to raise concerns about wrongdoing, thinking, well, if I give an extra page of material, is that going to cross this threshold? Or the standard is substantial and imminent danger to health or safety. Well, what does that mean? There's no judicial or legislative guidance as to this. So, of course, you should have a whistleblowing framework and a secrecy framework that operate in tandem. And broadly, the whistleblowing framework should allow people to raise concerns through the appropriate channels with external disclosure as a last resort. But why we, for many years now, have called for a public interest defence, and I note that the Law Council also supports that call as to other organisations, is because sometimes people don't quite meet all these frameworks. They're still ultimately acting in the public interest. Now, Canada...
It's like a long stop. A justice long stop.
Exactly. And Canada recognises that. Denmark recognises that. Recently, the UK Law Commission recognised that, has called for a public interest defence as part of British review of secrecy laws. So it's not outlandish to suggest that this would be an important last resort Yeah, and in those other jurisdictions, one of the criticisms that's often raised about public interest offences is it'll open the floodgates. You're only relying on a public interest offence if you're being prosecuted and you're in court, and the sort of salient deterrent effect of that is more than enough to mean that people will only have to rely on the public interest offence very much as a last resort.
It's a break glass in case of emergency.
Exactly.
Yeah. I don't want to digitally discriminate against the Law Council and others, but can I ask you probably to respond on the need or otherwise for a harm element in the defence to be established? What's the Law Council's position on that, and have you got some potential drafting we could consider?
We've got we've for some time been very supportive of a harm-based approach. Our submission doesn't make recommendations around that to the proposed bill. We've instead opted to try to refine what's in the bill and the terminology. They've obviously, for whatever reason, moved away from the policy position of a harm-based offence. We, as with others contributing to this inquiry, would agree that is probably the gold standard. But in terms of our recommendations, they go more towards the terms that are in the bill themselves rather than what's not there.
But do you think? I mean, this is why we're having this, to try and hopefully adopt a gold standard for these kinds of laws. Do the Law Council support putting efforts to put a harm-related element into the offence?
We would definitely support that. To the extent that there's already the capacity for it in the drafting, terminology like detriment, attaching some materiality to that threshold. But yes, we would support an approach that is harm-based.
Yeah, I mean, some of what I've heard from stakeholders and, interested members of the public is they look at this proposal from the government and they say, well, yeah, you're getting rid of 300 secrecy offences, but they've kind of never been used or hardly ever been used. And in return, you've got this devil's bargain of getting, a one-size-fits-all secrecy offence that just goes not just across the public sector, but across anyone who engages with the public sector. And they're looking at this as a bargain that Parliament shouldn't accept because how broad the new offence is. Does the Law Council have a view about, taking a step back and looking at the bill?
Thank you, Senator. We observe that while the range of secrecy reviews that have taken place over the past decade or so have considered a range of different options for drafting an offence, that drafting an offence which responds simultaneously to the allegations made against a partner of a consulting firm, as well as complying with the recommendations general movement towards a general secrecy offence, which is harm-based, hasn't been something which has been widely consulted upon. Our view is that some of these issues might have ironically been dealt with earlier in the process had there been earlier consultation on the drafting of the provisions. And so I think our view would be that we would need to consult further with our membership about how the Law Council would best like to see an offence that is attempting to address these correctly identified twin mischiefs of the absence of a general secrecy offence when existing section 112.4 sunsets, as well as the mischief communicated in the EM of attempting to deal with the narrow set of circumstances that arose in that particular example of a partner subject to multiple confidentiality agreements who leaked material in order to benefit their third-party clients, allegedly.
But that's... Sorry, you finish. Yes, sir.
I was just going to say that the Law Council's preferred position on how to address this is something upon which we'd prefer to consult further.
Well, I'm more than happy for you to take that on notice, and if you can respond in the notice period. I'm not quite sure how long we have for questions on notice.
11th of June.
The 11th of June. It's not the most generous consultation time that we're offering, but if you can take that on notice, I'd really appreciate that. But I mean, thinking about, you know, a consulting partner, again, you know, let's pick a hypothetical consulting partner given a bunch of early access to confidential information about tax changes, and then they go and, in breach of contractual requirements, leak that to their clients so their clients can rearrange their finances to avoid those tax obligations. That seems to me something that would meet the harm threshold anyhow. And if that's what's intended to be captured, then incorporating a harm element would seem to not offend that, if that's the intent.
Thank you, Senator. The reason why we would like to consult further on this is because the reviews have identified a certain subsets of types of harms to which harm-based offences ought to apply. So, and there is some, there's a question as to whether conduct of that kind, for example, would fall within the recommendations of the ALRC report. So while one could make the argument that such conduct may cause harm, there is some technical considerations that we would like to work through before.
And we'd want to ensure that concepts like political embarrassment or cost of themselves aren't the test, because there actually may be some public interest disclosures that, if they're acted upon, would cost the Commonwealth money to resolve. But if the only test was cost, that still might meet a harm threshold and enable someone to be prosecuted.
These are complex matters that we think are best addressed through an open public consultation process, Senator. That these are real live questions, and we observe that they may be ironed out best through public consultation around what the best limits might be to the expression of harms in this context.
Thank you.
Thanks.
Senator Shoebridge. Senator Polly.
Yes, I have just a couple of questions to the Human Rights Law Centre. You express in your submission that this bill will have positive impacts for your clients. Can you expand on what these positive impacts are and how they will benefit your clients?
Certainly, thanks, Senator. So the Human Rights Law Centre provides advice to people raising concerns about wrongdoing both in the public sector and in the private sector, and indeed private sector in relation to government wrongdoing, such as contractors, reducing the number of secrecy offences on the Commonwealth Statute Book, and tightening the drafting and clarifying the operation of many of those is, we think, a really good thing. That's why we broadly support the bill, although we've raised the significant reservations we have with the new low-lying general secrecy offence. One of the significant things the bill does is also remove liability for what we described as mere receipt. So one of the concerns as a legal service for whistleblowers, we often come into receipt of material in the course of advising our clients. We were concerned, and we raised these concerns in our prior submissions, that we could face criminal liability for the mere receipt of information where we were not otherwise actively making use of that information, i.e. we very clearly say we cannot help intelligence whistleblowers on our website. If someone emailed us unsolicitedly and gave us that material, there was a risk under the prior regime we would still face criminal liability. The bill addresses that following a recommendation to that effect by the National Security Legislation Monitor. So both our clients and then us, in the way we help our clients, will benefit from less secrecy provisions and greater clarity as to the operation of those secrecy provisions.
Great, thanks for that. You also express support for the removal of security classifications from the definition of inherently harmful information. Can you expand on how this will be a positive change?
Certainly, thanks, Senator. So this was a recommendation from memory that came out from the National Security Legislation Monitor and really went to rule of law concerns that imposing criminal liability on the basis of security classifications which are not necessarily fixed as a matter of law and which a third party may not necessarily have knowledge of was not consistent with a rule of law approach to criminal liability. So that was an issue that was extensively considered by the National Security Legislation Monitor. I'm sure the Monitor, I understand, is giving evidence later, could speak to it in more detail, but certainly information that is security classified may well be harmful and may well give rise to liability under secrecy offences if misused. But the question was how you attach that liability, and we don't think that prior approach was proportionate, consistent or necessary, and we think removing that and instead relying on a harm-based approach generally, as the bill broadly does, other than in relation to the low-lying offence, is a good thing.
Okay. Thank you, and thank you again for your submission. Thanks, Chair.
Concludes the questions that we have for you, or the time for questions, I should say, because I understand there is definitely questions coming to each of you on notice. And as you heard in my response to Senator Shoebridge, those are due by the 11th of June to the Secretary, please. You'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request corrections to any transcription errors. Thank you very much.
Thanks
for your time today.
Thank you very much.
We will now suspend and we will return at 12:45. We will resume with the Independent National Security Legislation Monitor via video conference for us and audio conference for those who are joining us online. Thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you appear?
Thank you. My name is Jake Blight and I am the Independent National Security Legislation Monitor.
My name is Secrecy and I'm a Senior Legal Advisor at the Office of the Independent National Security Legislation Monitor.
You might need to turn your video off because you're a bit scratchy coming through to us on your end, and hopefully that improves the audio. And do you want to introduce yourself again, Mr. Chatterjee?
Yep. So my name is Shinok Chatterjee and I'm a Senior Legal Advisor at the Office of the Independent National Security Legislation Monitor.
Thank you. Appreciate that. I think that is certainly much better than what it was. And if we need you to say something again because it's breaking up, we'll just let you know. Would you like to make a brief opening statement before we begin?
Chair, I would if that's all right.
Excellent.
Thank you for the opportunity to appear. As you probably know, my statutory function as monitor is to review certain laws that are currently in force in order to assess whether they remain necessary, proportionate and consistent with individual rights and Australia's international obligations. Historically, my office does not comment on bills, and I think this might be the first time a monitor has appeared before this committee. However, the bill you're currently considering is described as being in part to implement many of the recommendations of one of my reviews. As such, I hope that by appearing today, I can assist you in your task. As well as answering questions on my review and recommendations, I also want to mention in this opening statement a couple of technical issues that might not appear as important as they perhaps are. At the outset, I should say secrecy offences, I do believe, are a necessary and important part of our legal framework. It is and should remain an offence to disclose information that may actually harm national security, defence, law enforcement or other essential public interests. But the offences need to be well designed, they need to be proportionate, or else they can lead to unnecessary and indeed unhelpful secrecy in a democracy, and they can also undermine the role of the Parliament in setting the boundaries of the criminal law. I think this bill represents a substantial and welcome reform. It repeals many unnecessary offences, though there's still a lot on the books, and it improves clarity, proportionality and coherence across the framework. In particular, I welcome removing the application of an administrative security classification alone as a trigger for criminal liability and narrowing the overbroad dealing with offences, particularly for journalists and other non-officials, and better aligning aggravated penalties with culpability. These are important reforms and ones that I gathered a lot of evidence on and considered carefully in my detailed review before making recommendations that are reflected in this bill. But there remain some key things from my report that are only partially implemented by the bill, and the most significant of these is the retention of overly broad deemed harm offences and the introduction of a new general secrecy offence that is not harm-based. Briefly, it's my view that almost all secrecy offences should require proof of harm or likely harm, and that deemed harm, which of course means that the Crown doesn't have to prove that there was even a chance of actual harm, those deemed harm offences should be reserved for narrow categories where harm will inevitably or almost inevitably be the result in any case. Things like technical capabilities used to produce intelligence or the identities of covert sources and operatives. The government's response acknowledges my concerns and foreshadows further work, but the bill does not actually deal with these overly broad deemed harm offences or explain why their continuing breadth is considered necessary or proportionate. The bill also departs from a harm-based approach by introducing a new general secrecy offence in 122.4 that doesn't require proof of actual or likely harm and instead turns on whether the person intended to obtain a benefit or detriment with no seriousness threshold for those tests, and whether the conduct was improper, a term that may prove challenging to interpret in some scenarios. I also wanted to flag a couple of what might seem like technical points, but ones that have rule of law implications. The first is the proposal to have a savings provision that when the old general offence in 122.4 is repealed, would nevertheless keep it operating for 8 specific laws. Now, I haven't had the opportunity to consider if that retention is justified for those 8 laws, but I do urge the committee to consider that carefully. But the rule of law issue that I wanted to flag is that having a savings provision that is going to be a law that's difficult to find in future because it won't be clear on the face of the code or the 8 other laws that 122.4 continues to apply. And that's not consistent with the need for laws to be clear on their face. And I support what the Law Council said in this regard. The second one, which again may seem overly technical, but I think is an important principle, is one that relates to the Defence Intelligence Organisation, or DIO. DIO, and like all the intelligence agencies, has an offence that makes it illegal to deal with or disclose any information obtained by, made by, or on behalf of the agency in the performance of its functions. The challenge is, for DIO, those functions are not set by the Parliament. Unlike every other agency, Defence sets its own functions for DIO, and this means that the boundaries of the crime can be changed by the department at any time without parliamentary oversight. And I recommended that DIO's functions be put on a statutory basis in the same way that other intelligence agencies, such as the Australian Geospatial Organisation, which is also an administrative part of Defence, have statutory functions, or at least functions set out in regulation. What the bill does is it actually doesn't do that. It simply requires that DIO publish its administrative mandate from time to time. That's an improvement, but for me it doesn't address the rule of law issue. And this same issue arises for privacy and FOI, where DIO has functions exemptions, which again can be changed by the department at any time. Last thing I want to briefly mention is I note the proposal to extend the requirement that the Attorney General's consent be sought for all secrecy prosecutions. And I find it interesting that the bill does this rather than implement the PJCIS proposal from their Press Freedom Review, which is to consider extending a public interest journalism defence to other secrecy offences. And while I support the retention of the Attorney General's consent for secrecy prosecutions in Part 5.6 of the Code, in my view, the role of the attorney in these kind of decisions is to bring to the table matters that the CDPP doesn't consider in its public interest test. That is, matters that are peculiar within the knowledge of the executive, such as Australia's international relations or the risk of a prosecution disclosing national security information or information disclosed by a partner. And as a general principle, the consent of the AG is needed for those kind of things, but it isn't a substitute for statutory safeguards for other matters. Anyway, I'm very happy to answer the committee's questions on these or any other issues that relate to my secrecy review. I'm happy to assist.
Thank you very much, Mr. Blight. We'll proceed to questions and start with Senator Cash.
Thank you very much, Chair, and thank you very much, Mr. Blight, for A, your submission, B, the body of work you've done, because this has been an ongoing body of work for you, and C, appearing today. I do want to get quite a bit of your evidence on the record, hence some of the questions I ask you might think, well, it's in my submission, but I do want to actually get it on the record for the purposes of this hearing. So in the first instance, the bill very much, I understand, implements parts of your review, in fact, the majority of your review. You had 15 recommendations. I understand that 12 have been implemented by the government and 3 have not. In relation to the 12, are you satisfied that the legislation properly reflects those 12 recommendations? And in relation to the 3 that have not been acted upon, can you tell us A, what they are, and B, what that actually means for the legislation? In other words, does the government need to pick up your 3 recommendations?
Okay, if I could take you, if it's not too long-winded, I'll take you through them.
Thank you.
So the first one is about the security classification. I'm very satisfied that's been implemented. I'm very satisfied with the bill. I have no concerns about recommendation 1.
Yep.
Recommendation 2, the government didn't agree. This one is about the deemed harm offences. At the moment, it's an offence to disclose anything about ASIO or DIO, regardless of whether it's about their stationary order or about their most secret agents. The government noted but didn't accept that, so I'm not surprised that's not implemented in the bill. But I do think, and I remain of the view, that that's an excessively wide offence. you still need to keep almost everything about those agencies secret, but not everything.
Can I just ask on that one then, if we're going through them? So what does the bill do versus what your recommendation is?
My recommendation was that the deemed harm offence should not apply to all information connected to the agency's functions.
Yep.
So, for example, the stationary order. I said the deemed harm, so this is where the Crown doesn't have to prove any harm,
Yes.
should only apply to their intelligence information and their intelligence operations, capabilities, technologies, methods and sources. So the really secret stuff.
Yep.
Everything else I said, if the stationary order really would harm national security, that should be in the harm-based offence. You should have to prove that something that's not about intelligence or your capabilities really should be prosecuted. So that's not implemented. The government didn't agree that in its response. My preference would be to see that implemented, but I accept that that isn't implemented in this bill.
Okay, so everything's within the harm offence, is it? You've got to prove it.
At the moment, the way the bill leaves the law is how it is now. Everything is in deemed harm.
Oh, everything is in deemed, sorry, everything is in deemed harm. Yes, okay.
All the intelligence agencies, including DAO, which doesn't have a clear boundary set by Parliament.
Okay, thank you.
The third recommendation was about how it should apply to methods, technologies of law enforcement. I think the government agreed this in principle. They haven't implemented that one yet, and they've said that they're doing further work on it. It may be that they're doing that as part of the electronic surveillance review. I'm not actually sure. But again, this relates to that question of how much should be covered by deemed harm. So it was agreed in principle, but it's not really implemented in the bill. And the bill doesn't explain why not.
Okay.
The fourth recommendation was again about deemed harm. So all the deemed harm offences are mirrored, not only in the Criminal Code, but also in the ASIO Act and the Intelligence Services Act. So that's back to that same principle of whether the stationary order and everything should be treated the same way as your covert capabilities. Again, the government didn't agree that, so I'm not surprised. The fifth recommendation was about DAO. I think we've covered that one in the opening statement, unless you have questions.
Well, just in terms of what the bill does, you're saying it doesn't go far enough and the boundaries of the crime could potentially be changed by the Parliament at any time, so you do need those boundaries.
That's right. In my review, I flagged two issues. One is that nobody can find DAO's functions because there's no law requiring they be published. That's fixed. The bill resolves that. The second one is that instead of the Parliament determining the functions, the department does. That is not fixed, and I think that should be fixed for secrecy, for FOI and for privacy. It's the role of the Parliament to determine the very edges, even in broad terms. I mean, the functions of ACIS, for example, are in very broad terms.
Okay, yep, thank you.
Recommendation 6, which is we're now moving to the harm-based offences, which is my preferred structure for offences.
Yes.
It's largely implemented, but not quite. But I think it's largely implemented, other than I'd suggested narrowing international relations to diplomatic and military law enforcement intelligence instead of relying on a broad concept that includes economic. But that's a relatively narrow point.
Yeah, okay, yeah, I understand that. Yep.
The seventh one was about dealing with. That's largely implemented. This is really a bit of a technical one because dealing with and communicates overlap. That's largely implemented, I think. And Chinook will tell me if I'm wrong in a moment. Importantly, recommendation 8, which I think is a very important one. This is the one about journalists and other non-officials. This is implemented. So for a journalist, simply receiving something will no longer be a crime.
Yes.
It's only when they go ahead and publish, for example.
Yes.
So that's important. That dealing with is implemented.
Yep.
Number 9, proper place of custody. Everyone agrees that was a bit of a no-starter offence and that's repealed. Aggravated circumstances, which is number 10, that is implemented in full. So now there'll be a special aggravated crime if you're especially trusted, if you have the highest level of security clearance. It makes the offence more secret. But the other things that were there are repealed because they're not really aggravated things that aren't already taken into account by a court in sentencing.
Yes.
Number 11 is the replacement general offence. I think that's probably a longer discussion because I only set out principles.
Yes.
Maybe we'll just park that one. Number 12 is largely implemented. This is about non-officials where I think it should be arm-based. And that's largely implemented. I can send you, I'm certainly happy to send, I'm happy to table my table in detail if that helps.
Yes, please.
13 is journalists. Is implemented in substance. It's the
Schedule 3, is that it? No.
Chinook, help me with schedules, sorry. No, that's about consent, sorry. Schedule 3 is consent. 13 is I said there shouldn't be a general public interest defence.
Yes.
Which, but it's a question of a technical one of exception rather than defence. I'm satisfied with that one. 14 might be the one you're thinking about, which is AG consent.
Consent, yep.
So what I said is keep consent for the criminal code offences, and the role of consent is for the attorney to consider those things that are peculiarly within the knowledge of the executive. It's, for example, not for the DPP or the AFP to worry about Australia's international relations. Would bringing this prosecution harm Australia's international relations? That's when I think the role of consent is very important, particularly in secrecy, espionage, foreign interference. Those are the kind of things you need AG consent for. And the last recommendation, which has nothing to do with the bill, was actually about the Commonwealth prosecution policy. I said the government should refer to the DPP and suggest she add something about journalists specifically into the DPP guidelines. That is, of course, an independent matter for her, not for the government. So it's not surprising that's not in the bill.
Okay. Can I ask, you made a comment just before 1 o'clock in terms of some of the recommendations and the government had foreshadowed further work. Does that mean another body of work coming forward or as part of this bill?
You would have to, what I hadn't said is in the government's response, which is a couple of years ago now, they foreshadowed further work as to what the department's doing and whether there's another bill, that one's for the department.
Okay, no.
So I'm referring to their old response.
Understood. Okay, thank you. I just wanted to clarify that. Can we just now work through each of the issues? So could we start with the new improper offence and the harm-based failure? So the submission says the new general offence does not require proof of actual or likely harm and instead turns on whether the use of information was improper. So you reviewed the whole area for the Parliament. So is it your evidence that the government has built a new criminal offence that can be made out even when no harm to the public interest can be shown?
That's right. So when I looked at this, when I did this review, of course, the provision you have in front of you didn't exist. That's
correct.
Drafted.
Yes.
What I set down was a general principle that said if you're going to send someone to jail, it should be for either causing harm or at least doing something that's likely to cause harm.
Yes.
What the new 122.4 does, if you look at 122.4 subsection 2, it actually says really clearly it's not necessary to prove that anyone obtained a benefit or that anyone suffered a detriment. So it's phrased in terms of benefit and detriment, but you don't have to prove that there was one. Benefit and detriment is not quite the same as harm to a Commonwealth interest. It's not an unknown concept, nor is this concept of something being improper unknown, but it's not quite the same as there being express harm. You know, detriment, it's not that clear. Does it include damage to public interest? It could be clearer. If you wanted some guidance very briefly and only this morning, so this is not detailed consideration, I noticed that For example, the bribery offences, if you look in 70.2 capital A of the Criminal Code, they give quite a lot of guidance in what should be taken into account and whether deciding something was an improper action. So harm-based would be my preference. If the government and the Parliament want to go with improper and benefit detriment, I encourage the committee to consider whether it's possible to be clearer what you mean, and that there might be models like the bribery offences that could be considered as you work that through. I'm afraid I didn't do 6 months of work on this bill, so I can only give sort of general comments at this point.
Okay, so in terms of the work that you've done on this bill, how much time have you managed to spend on this particular bill?
I confess that today is my second day returning from extended medical leave, so I'm sorry, Mr. Blythe, I did not know that. No, I confess I've had a fairly quick look at the bill. My colleague Chinook has had a more detailed look. What I am satisfied of, as I said, is some very important features of my recommendations, particularly around classified information, dealing with for officials and aggravated offences. Those are clearly and solidly implemented by the bill.
Yep, understood. Just in terms of the new general offence and your preference that it be harm-based, but if it's not, that further guidance can be given in relation to improper, etc. Have you managed to have a discussion with the department in terms of why they've gone down the other approach as opposed to the harm-based approach?
No, I haven't discussed that with the department, and I think they're best placed to guide you on that. My general comment is that I would encourage the committee to consider this offence in the suite of offences. It is, of course, a lesser offence.
Yes.
But there are so many secrecy offences, not only in the code, but everywhere, that you want to look closely for what you think the gap is, and that in plugging that gap, there isn't inadvertent overexposure. I do understand that the department will have no doubt identified a gap. My concern, for example, is, and take an example, for example, if someone works in an intelligence agency and they want to disclose something not classified, so something like bullying or harassment in the workplace, something that is not connected to an intelligence function. At the moment, that's a deemed harm offence.
Yes.
But it's also, would it be for the benefit of the person? Well, maybe they're trying to get onto the detriment of someone else. Would it be improper for them to disclose that? You know, they're not going through the proper channels, they're not going through the PID Act, which says go to the Inspector General. I doubt that's the kind of thing that is intended to be captured by this offence, but it's the kind of thing that might accidentally be captured. So I do encourage you to explore with the department what they intend to capture and whether there may be tighter ways of being clear what the Parliament means by improper, benefit and detriment.
Thank you for that. If you look also at the explanations given for the way the drafting has been undertaken, the new offence is also aimed at that PwC style conduct. You looked at whether there was a genuine gap in the criminal law. In your assessment, was a broad new improper use offence the only way to close that gap, or could it have been done in a different way?
Didn't really assess that in detail. I do acknowledge that type of scenario could be a gap. The questions to ask are, is the criminal law the appropriate vehicle?
Yeah.
If the answer is yes, is there a way of targeting an offence that doesn't inadvertently pick up other things? The general principles I set down reflect sort of long-held principles of other law reform bodies like the ALRC, that the crimes, the criminal law really should be about harm or risk of harm to national interests, defence, security, functioning of government. How far should it go? And ultimately that's a policy call for you, for the Parliament. I just encourage careful consideration of potential inadvertent overreach in that.
Okay. If we now look specifically at the deemed harm offence, and that was, of course, recommendation 4 of your review, and you've said today, both in the submission and in your oral update, you've called for the narrowing of the deemed harm offence, and in particular applying to officials connected to certain intelligence agencies. The government hasn't accepted that. So what's the practical effect of leaving those provisions as wide as what they currently are?
So it's a general principle, again, it's a general principle of criminal law. I think the Crown should have to prove at least a risk of harm before it can prosecute someone. I think that's an important general principle of criminal law. I think you can make an exception for categories of information that are incredibly obvious that they're going to be harmful. The identity of sources, and I'm quite generous in how broad I would call that. Intelligence information, how it's produced, how it's analysed, how it's collected, relations with partners. But that still isn't everything about an agency. And to use my bullying and harassment example and expand that further, let's say you work in DAO, and I'm just using them as an example.
Absolutely, yep.
DAO is a very good agency. I have no qualms with them. But let's say you work in DAO and you feel that you're being harassed because of your race, sex, gender, identity, whatever, and you're getting bullied in your workplace in the way you do your work, that is covered by the deemed harm offence.
Yeah.
Whereas if you work next door in another part of defence, it's not. And there isn't any difference in the harm to the Commonwealth in you disclosing that. It also encourages people or discourages disclosures on things like procurement fraud. Let's say you think there is procurement fraud in ASIO's stationery order. Again, just a hypothetical example. What's the harm in disclosing that? So I have both a principled concern about deemed harm being too broad and a practical concern about the sort of chilling effect on disclosures of things that people should be able to disclose. So it's both a principled and a practical, and it's particularly around things that are not connected to the secret stuff they do. The other point I'd like to make is that we think of our intelligence agencies as only doing secret things. But remember, the Australian Geospatial Organisation sells maps to the public.
Yeah.
They have non-secret functions. ASIO has all these new functions about firearms. I haven't looked into those in this. ASD has a huge effort on cybersecurity that's not actually classified. It's about public outreach and things. These are offences that were designed with ASIO and ASIS in mind. I mean, ASIS, there's pretty much everything they do is very secret, but we've just applied it across the board and haven't updated it to really acknowledge not everything is as secret as perhaps we first think of.
No, and I think that was a comment made this morning that often people will err on the side of secrecy just to be safe.
I think that comes up both in that and it comes up in classification. And
classification as well, yeah.
People, there's no incentive to down-classify and plenty of incentive to over-classify. But I think that's resolved in the bill. I think removal of security classification resolves all of those problems and it doesn't leave any gaps. So I'm very comfortable that one's addressed in the bill.
Just in terms of the narrowing the definition of the intelligence agency limit, confining the law enforcement category, I think the government back in 2024 said that it would look at the narrower definition. That obviously hasn't been adopted in this bill. I appreciate what you've just said about you've only just come back. So perhaps has anyone else in your office, perhaps Mr Chatterjee, been able to have a discussion with the government as to why these things have not been put in place in the bill?
We haven't been in a position to have those discussions.
Okay. How long have you had to look at the bill, Mr Chatterjee?
So we've looked at the bill following it being made public. So the same consideration.
Mr Chatterjee, your sound is not being great at all.
I can perhaps help here. It's not really the role of my office to look at bills.
No, I do appreciate you said that up front.
Mr Chatterjee would have only looked at the bill when it became public, and I think that's quite proper. I did, before I went on leave, have some broad discussions with the department. It's not uncommon for me to discuss, make sure they understand my recommendations, but I don't seek to sway the government's decisions once I've made my recommendations. So I wouldn't be concerned or take any implication that we've been under-consulted. That isn't our role. We try to assist the committee, but really we can only assist with what we looked at in the review.
No, and thank you. I appreciate that. I'm just looking through, just in terms of the harm, the undefined word defence, the offences for officials turns in light on harm to defence, yet the bill leaves that word undefined and relies on its ordinary meaning. You recommended a definition. Is it Yep, so there should be a definition.
I think there's benefit in a definition. This is one that I think could go either way.
Yep.
While I think there is some benefit in a definition, there is some history to what the word defence means, capital D defence, and I think courts would work with that. I think where we get into challenges is the Defence Force does all sorts of things. It fights bushfires, it assists in floods. You know, there are some things that simply shouldn't be covered by the secrecy offences. So I think there is room to identify defence as a definition. I don't think it's utterly critical. I note that in the context of reviewing the NSI Act, Mr Donaldson, my predecessor, made some recommendations. My comments sort of picked up his and said here would be a way of going forward. I don't think it's the most critical aspect of the bill.
Okay. No, and thank you for that. In terms of the new offence in everyday Australians, this has again been the subject of some discussion. So the new offence reaches people who provide unpaid or voluntary services to the Commonwealth. So a volunteer or a community member helping out in an agency could potentially now face a criminal offence built on the word improper. Do you have any comments in terms of how that part of the offence is actually looked at? And whether or not it goes too far?
Well, first thing, just to give context, is that all of the offences apply to both Commonwealth officials, which has a broad definition, and people. Then that language of providing services, etc., that's common through all the offences. So that's already there even in the more serious offences. And I think that question of what's proper and improper does turn a bit on who the person is. What would be improper for an official with a top secret clearance and a detailed knowledge of how harm could be may be different for a junior person who's come in to volunteer to help something and comes across something. So you've got a little bit of catch there. I think what I was trying to say in the review is that there really is a difference in duty and responsibility between those who go out of their way to work for the Commonwealth. You're paid to work for the Commonwealth, or you're doing something pretty close to that. And I do understand the KPMG type scenario where you might have some people who are being paid directly and others who work for the firm but are not working on that case. There's a question of, are they being paid by the Commonwealth? And I understand the need to pick that up. But at the big principle level, all of those people who are doing something for the Commonwealth directly, I think, have a higher duty, and that's reflected in the Act and the Bill, higher offences, than people walking down the street, than journalists, than academics who are doing other things. And those are really dealt with in the offence for non-officials, which needs to be tighter and harm-based and have lower penalties. And that's largely reflected in the bill.
Oh, so you're happy with the drafting of the offence for non-officials?
So
I shouldn't say happy, that's the wrong word to use. Is there anything that you change in terms of the drafting?
Well, we jumped from the new offence to the offence for non-officials, just to be clear.
Absolutely, yes.
And I haven't, I confess, gone through the offence for non-officials exactly in the drafting yet, but Mr Chatterjee, jump in if I'm wrong here. I think we've said that in principle it picks up the main points, which is to make it harm-based. I think we had some slight difference around how you describe the harm to law enforcement, but it is largely consistent with what we recommended. And I can come back to you on that.
I'm just making a note, that will...
And also the Secretary are going to be in touch with Mr Chatterjee and ask if he can join us via teleconference instead. Yes, so I think they've just sent you an email, Mr Chatterjee, so that way we might be able to hear you a bit better as well. And just as Mr Blight is inviting you to make some contributions. So just for the committee's awareness.
Thank you.
Sorry for that. I'm just, while he's jumping onto that other call, there were some quite technical points that have definitely been implemented about SBS and ABC being, I think, probably inadvertently swept up. The dealing with material.
And that was one of your recommendations, wasn't it?
Yeah.
That was inadvertent.
The other one is, I think, very small differences in, we would have perhaps put it serious harm versus harm. I think it's largely consistent, and I'll come back to you if necessary with any clarification on that.
Okay. Could I just go to your recommendation 13, suggested recasting the journalist offence as an exception rather than a defence, which would have signalled that public interest journalism is not a crime. How does that work in terms of the way it actually has been drafted?
So the difference here isn't that big in law.
Right.
Because whether something is a defence or an exception, once the initial prosecutorial, once it's been raised by the defence in a sort of credible way, a certain burden has been lifted, then the Crown has to prove it. Whether it's an exception or a defence, in practice in a prosecution, it would work the same way about who has to prove what. What I got a lot of evidence on in my review is that, yes, that's a very technical legal answer, but people who work in the journalism, work in the field, they see an offence and they feel that therefore they'll be more cautious, particularly independent journalists who don't have the backing of News Corp's big legal team to help them, for example. They're very reluctant to report in this area. They're very cautious, and that has a chilling effect. So the evidence in my review from those organisations was that turning it around, changing the drafting in a way that probably wouldn't change the law, might provide more comfort. So I didn't phrase it as a recommendation that would change the law.
Right, okay.
It's really around signalling the way it's described. So that was kind of the principle of that recommendation, because many journalist groups lobbied me to make a general public interest defence, which is wider than the journalist defence. And I carefully considered that. We went through a lot of evidence in it. In the end, I didn't recommend that. In fact, I don't.
Can I ask why? Can you take us through why? Because it was something that was raised by previous witnesses.
It was, and I know, the ARTK has made a very impassioned case on this. I think for professional journalists, the defence that we have is adequate, the things that they do in the public interest, and it works well. It's challenging to make that a general public interest for anybody who claims themselves a journalist. It's also challenging to bring that forward to beyond journalists, to the people who give journalists information, because we have a scheme in the Public Interest Disclosure Act, which is separately under review, not by me but by others, and does need some work, that is designed to be a place people go before they go to journalists, a place officials go before they go to journalists, and it would pretty much do away or undermine significantly that scheme to say that, if you think it's in the public interest, you can go straight to the media. So if the Parliament has said we need a public interest disclosure scheme, even if the government and the Parliament are working on refining it, then it seemed to me not useful to completely undermine that scheme with a very broad exception. It also shifts, instead of the Parliament being responsible for the detail of how a public interest scheme would work, it shifts it to the judiciary to really decide, is this going to be the public interest or not, as the only test. So those were some of the reasons, and it is detailed in the report, and I defer to that, which is written carefully as the reasons, but I didn't think it was necessary for professional journalists with the defence. I thought it risked being overbroad and undermining the schemes that the Parliament has already put in place for public interest disclosures.
Thank you for that. Can I also ask you one question? I don't know if you will be able to answer it, but you did touch on it. So the explanatory memorandum provides protection to people acting in a professional journalistic capacity. What do you take that to mean in terms of you actually just referenced professional journalists versus, so what do you, because it does seem to be a bit of, what does it actually mean?
It is, and I think where they're trying to go with that, we do discuss this in the report, and when Mr Chatterjee comes back online, he'll find the page for me.
He's joined the teleconference now.
people who work in an industry, who are employed or not necessarily employed but are engaged in mainstream, not necessarily hard copy, but in mainstream media. This is what they do. It's not everybody who has a website and uploads a blog. So it's meant to be, in our culture, there is both freedom of expression for individuals, and there is a specific role for the press and the media and professional journalism in active engagement and disclosures and holding people to account. It's trying to balance those and provide a greater degree of protection for that fourth estate, for that professional journalism and media, without saying everybody who uploads something to a website
is suddenly availing themselves of.
Those people still have the other protections, the Public Interest Disclosure
but
Act.
just
they still have ordinary political communication, but when it comes to information that is or is likely to be harmful, because remember, this is a disclosure to an offence where there is likely harm. Okay, so if you take something like the Afghan files disclosure, for example, and that predates these laws, but you would say, it was foreseeable that disclosure would harm Australia's relationship with Afghanistan. Okay, it was foreseeable that disclosure would cause harm to the reputation of Australia's Defence Force. So therefore that would be a crime, but the professional public interest defence would then allow the courts to say, well, in the role of a professional journalist disclosing, credible, serious, but not proven, to be clear, allegations of war crimes, well, that is public interest journalism. So it is, I think, meant to be and operates as a safeguard in that kind of situation, things that would otherwise fall within the criminal law.
Just on Schedule 3, so your review, or neither your review nor the AGD review recommended the expansion of the Attorney General consent to every Commonwealth secrecy offence. On what basis did you believe that it shouldn't be expanded, and did you want it to just basically remain as the Porter direction? So consent is required, but via the Porter direction?
So there's a couple of things there. First of all, my review was focused on the criminal code, so I didn't make recommendations about secrecy offences writ large. What I said was that in the context of secrecy offences, and I'm of the same view for espionage and foreign interference offences, there is a particular role for the executive government in declining to take forward a prosecution where there are things uniquely within the knowledge of the executive, like harm to international relations. And I think that should be maintained. It's not a general, does the attorney think it's a good idea? It's the things matters within the executive that the attorney exercises on behalf of the executive. And remember that, and as I'm sure you know, there is also completely separately in the Judiciary Act a general power for the attorney to discontinue any prosecution. That still exists. So it's not technically a withdrawal of consent, and it applies to any prosecution. So, for example, secrecy offences are narrow. If you take Mr McBride's case, for example, remember Mr McBride was actually charged with, I think, theft and Defence Act offences mostly. It wouldn't be a secrecy consent prosecution come into play, even under the bill. The question there would be, like in the Caleri matter, the attorney exercised a discretion under the Judiciary Act. So I didn't make a recommendation about other secrecy offences. If your question is, do I think there is a role for consent where there are matters peculiarly within the knowledge of the executive? Yes, I do.
So would that be the Porter direction?
I'm back to that one second. Do I think, I'll lose my train of thought. Do I think that consent is a substitute for statutory safeguards, like a defence for journalists? No, I do not.
Right,
In relation to the Porter direction, which I think has been reissued since then by the subsequent attorney, it doesn't require consent, as I understand it. This is a direction to the AFP that requires they, in a matter involving a professional journalist, the attorney expects the AFP to take into account the importance of a free and open press and to consider broader public interest implications before investigating action. So it operates at a different stage. It's not a consent. It's a please take extra caution kind of thing, which is a perfectly legitimate thing for an attorney to direct. It isn't a replacement for a consent. I did flag one small technical thing, is that the direction only applies to prosecutions of Commonwealth officers, but the offences, of course, apply to Commonwealth officers and all those other people who do work for the Commonwealth voluntarily or otherwise. So if it was to be reissued, it probably should be reissued in that broader sense. But I do recall speaking to the AFP, and their practice is to interpret it in the broader sense. So that's a technical matter, but it's worth noting.
So in terms of the Attorney-General's consent being extended by Schedule 3 to all secrecy offences, what are the implications? What do you see are the implications of that?
Apart from work for the Attorney-General, I think it is not unreasonable if the secrecy offence is of a type that there are likely to be matters peculiarly within the knowledge of the executive. So, for example, any matter that goes to defence, international relations, national security, every secrecy offence, I think there's 500-ish still on the books. I think it's worth considering whether every secrecy offence raises things peculiarly within the knowledge of the executive. I can't name them off the top of my head, but there are plenty of acts and offences that aren't obviously about the kinds of things that the executive government has unique knowledge of. We do have the CDPP who makes that independent decision on public interest, and they do that routinely, and they do that for all matters that the CDPP should be aware of. It's just those unique executive things like international relations that it is not proper for the DPP to worry about. That's proper for the executive government to worry about.
Just in terms of the bill itself, I think there's a general theme throughout the submissions, in particular, say, in terms of the harm-based offences, the deemed harm, the non-defining of certain terms, etc. And you've certainly gone to a number of them yourself in your submissions. If the bill was to pass as is, what would be the effect of that in terms of prosecutions? So you don't have that level of specificity or the guidance being given in terms of what the offences are, who is actually, going to be in line to potentially be prosecuted, etc.
We only answer that at a general level, which is what I hear over and over again from AFP and DPP, which is the more specific the Parliament is, the easier it is to understand the boundaries of the offence and therefore to prosecute. That's a general high-level comment rather than a line-by-line comment on the bill, I'm afraid. You can over-define, but I do think that perhaps, particularly in the general offence, the committee could consider whether there is room to look at other models to be a little tighter on the definitions there. As I said, I'm less worried about things like the definition of defence than, as I said in my report, but I am encouraging the committee to think about the new offence. As I said, I'm sorry, but I haven't had the chance to consider it in as much detail, so these are just answers of principle, Senator.
No, that's fine. I notice that we're almost at time, so look, I might leave my questions there, but I'll review your opening statement and see if there's anything further, Mr Blight, that I may place on notice.
I was just going to say, Mr Blight's mostly covered the questions that we had in responding to yours.
We've done quite well then.
So you've done an incredible job there.
That was, I really appreciate that. That was excellent evidence.
No, I think that was really helpful. So thank you very much for that. Thank you so much for taking the time to give evidence today, and apologies for the technical challenges, Mr Chatterjee. Senator Cash has noted that there's probably going to be some questions on notice to you. Can we please have the answers to those by Thursday, the 11th of June? And you'll be sent a copy of the transcript of your evidence and have an opportunity to request corrections to any transcription errors. Thank you very much.
Thank you, Chair. Thank you, Senator.
Thank you very much.
We will now move to our next witnesses today from the Centre for Public Integrity. How are you, Professor Appleby?
Good afternoon. Well, thanks. Thanks, Chair.
Excellent. Can hear you loud and clear. Thank you so much for taking time to give evidence to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat as well. I remind senators and witnesses that the Senate has resolved that an officer of a Department of the Commonwealth, is this relevant here? Commonwealth or state, I didn't think that was, I'm like, I don't know that that's a thing here. Maybe we'll just go to, for the Hansard record, would you please state your full name and the capacity in which you appear?
Sure. It's Professor Gabrielle Appleby, and I'm appearing as the Research Director for the Centre for Public Integrity.
Yeah, thank you very much. Have you got an opening statement, Professor?
I do, thanks.
Excellent.
So thank you, Chair, and thanks to the committee for the invitation to appear today, and thanks to the Secretariat for accommodating my time requests. I just really want to make 3 points in the opening statement and reinforce some of the comments in the submission. So first, I want to restate that the Centre does welcome the government's commitment to progressing reform in this area. This bill does represent the next stage of a really substantial body of work that has been undertaken over many years, including reviews by the Law Reform Commission, the Attorney General's Department and the Independent National Security Legislation Monitor, who the committee's just heard from. The Centre welcomes the fact that the government is continuing to engage with this work and as a next step has brought forward legislation to implement the reforms. As we note in the submission, secrecy laws do sit in tension with principles of open government, but nonetheless there will always be circumstances in which secrecy is necessary. But secrecy needs to remain an exception rather than a rule, and particularly where there are criminal sanctions, these need to be reserved for circumstances where they are genuinely necessary to protect important public interests. Now, the broad direction of this bill reflects those ideas, and in particular, we welcome the repeal or decriminalisation of a number of secrecy offences, which represents a really significant reform effort. The second point concerns both the substance of the bill and the process by which law reform recommendations are implemented. The Centre has provided to the committee an analysis of the ALRC report from 2009, the Attorney General's Department's review from 2023 and the Insulam review in 2024. And this analysis demonstrates that the government has implemented a substantial number of recommendations arising from those processes. We've indicated where implementations have been fully or partially implemented. However, the analysis also demonstrates that there are a number of recommendations that have only been partially implemented or not implemented at all. Many of these concerns go to the new proposed general secrecy offence and the change from the focus on the need for harm to identified public interests, and rather the introduction of these thresholds that the committee has heard so much about today of benefit or detriment and impropriety. And also the extension of the offence to those providing potentially unpaid services to the Commonwealth. Now, these are concerns substantively that have been raised by other submitters, and what the Centre has tried to do for the committee and for the Parliament is to set out a transparent assessment of where recommendations from these previous reviews have been implemented or where they've been partially implemented or not implemented, and set out our reasoning behind why we've said that. I note that in Senator Cash's questioning of the Insulam just before, she did the same in relation to his review, and it was really enlightening to hear his own explanation of where he thought his recommendations had been adopted or largely adopted or not adopted. So we think that this is an important process. It highlights a couple of other further issues. The first is that even where legislation does follow independent reviews and consultation, there does remain a critical role for further consultation on the specific legislation itself. Devil is often in the detail. The translation of general recommendations into specific provisions requires drafting choices about thresholds, tests and definitions. In this particular case, there's been a new direction taken in relation to the general secrecy offence. Now, the explanatory memorandum explains that some of that change in direction can be traced back to the concerns raised by the use of Treasury information by the consulting firm in breach of obligations, and these concerns arose after the reviews. And that may be the case, and we're sympathetic to those concerns, but it does mean these concepts have not been pressure tested through the review process that the other ideas of harm-based offences had been, and we are seeing the result of that in submissions to the committee. So we say that when legislation introduces new legal concepts or departs from the precise approach in recommendations, really is best practice to have further consultation, whether that be on exposure draft or longer consultation periods for the legislation itself. This plays a valuable role in ensuring that legislative drafting choices are properly scrutinised. And the second is a more general accountability issue. Governments frequently commission major reviews, inquiries and independent examinations, and this should be welcomed in policy development, but they do often consume significant public resources. They rely on substantial expert and public input, and yet sometimes it's difficult for Parliament and the public to precisely identify where recommendations have been implemented, have not, and we suggest, and we have tried to do so in this particular instance, that there's a great value in developing a more transparent mechanism to show where recommendations from significant reviews and inquiries have and have not been implemented. So my third and final point concerns a more substantive issue that the Centre for Public Integrity raised in its submission to the Attorney General's Department 2023 review, but which has not been picked up in this bill. This is an issue that concerns executive control over disclosure by integrity agencies. And in particular, we focus on Section 37 of the Auditor General Act. And my apologies to the committee, there is a typo in our submission. It refers to Section 47. The submission back in 2023 has the correct section, and I apologise for that typo that has crept in somehow. Now, that provision allows the Attorney-General to issue a certificate preventing the Auditor-General from including certain information in a report to Parliament on the basis that disclosure would be contrary to the public interest. The Centre remains concerned that these provisions place ultimate control over disclosure in the hands of the executive, even where that information in question has been gathered by an independent integrity institution for the purpose of reporting to the Parliament to hold the government to account. The Auditor-General himself has previously raised concerns about the incursion of such a provision in his ability to perform his function, particularly where it's been used in relation to commercial and confidence information. So the Centre continues to hold its position that this provision and other provisions of this nature need further consideration as part of any broader review of Commonwealth secrecy and disclosure laws, given it hasn't been taken up by these reforms. Thank you, committee, and of course I'm pleased to answer any further questions.
Thank you so much, Professor. We will proceed to questions and begin with Senator Cash.
Thank you, Chair, and thank you, Professor Appleby, for those opening comments. Can you just remind me, was there an exposure draft of this legislation, or was it released and then we're having the committee hearing?
Yes, that's right. And I think one of the revealing dimensions of that is the Law Council's evidence today, where representatives of the Law Council indicated that their submission had very much been about suggesting amendments to address their concerns for the general secrecy offence based on the offences that had been introduced into Parliament, rather than perhaps going back to a more first principles basis if it was more of an exposure draft level of the process. It does change how people engage with legislation when it's been introduced to Parliament as a bill.
No, thank you, and I appreciate that. If we could work through your submission then, and in particular starting at page 2. So you've put down there the ALRC recommendation, Rec 5.1. Then you've got, obviously not incorporated in the status, the new target offence in section 1224 does not require harm to public interest. It requires intention to obtain a benefit or cause a detriment. Can you take us through how you see the new target offence playing out and whether or not there's any changes that you think need to be made to it?
Yeah, sure. So we haven't addressed whether there needs to be changes to the introduced provision in our submission. But what I would say is that we endorse the concerns that have been expressed by the Law Council of Australia in relation to the undefined thresholds of benefit or detriment, and also the undefined concept of impropriety, or that it's improper, particularly where we're dealing with a criminal offence. And that there are other examples in criminal legislation where concepts such as improper are much more clearly defined. What we endorse that position that there is sort of a high level of ambiguity, therefore uncertainty, introduced by all three of those concepts in the new general secrecy offence. That does concern us, and we also are concerned by the Law Council's position in relation to, or endorse the Law Council's concerns in relation to the extension of the offence to those providing unpaid services to the Commonwealth, and the breadth of what that may include, noting that it may not result in prosecutions of those providing voluntary advice to government when requested, but the fact that the offence is there and it can potentially extend to that kind of services does have a chilling effect, and it doesn't meet those principles that I started my opening remarks and our submissions with, is that you should keep secrecy as an exception, and that needs to be narrowly tailored to the purpose that you're trying to achieve.
I don't know if you've heard other evidence, but it has been raised, the concerns that volunteers potentially will be captured by the proposed offence at section 122.4. Specifically, volunteers asked to provide expertise through, say, in-confidence consultation, for example, on draft legislation. Can I get you to further elaborate on your response to those concerns? And in particular, does the new offence create any scenarios that materially increase the chance of such prosecution of civil society organisations or other volunteers as compared to the existing laws?
Yeah, I think that the new extension to those providing unpaid services to the Commonwealth is where the cause for concern is. And Senator, I'm not sure, to answer your question, I think that it's more likely to have a chilling effect on those being prepared to engage with the government in those unpaid service roles, often at great urgency. For example, I've previously been involved with the Law Council in providing advice as part of an expert group in relation to proposed legislation. And I think rather than an increased likelihood of prosecution, the increased likelihood is that people just won't engage and give their pro bono service and expertise to those kinds of exercises, which I think are very beneficial. I think it is beneficial that the government is able to reach out to experts and receive advice on legislation as it's being developed, or policies, or draft or regulations that are being developed, and this would if you're giving up your time anyway, and there's the potential that you'd be caught by this provision and you would otherwise have to put in place various arrangements, you're just going to say no. And that's where I think the problem is, rather than the likelihood of prosecutions increasing.
Yeah,
so it will change behaviour.
Yeah, it changes behaviour, and potentially not for the better. Just also in terms of the commencement of the legislation, if it was to pass, it all commences on royal assent. How does that then also impact the people you're talking about, who may already be in possession of certain information, and overnight the law changes, but they may not be engaged in this process? How do you see that playing out?
Yeah, look, the Centre for Public Integrity itself has not made submissions in relation to this point. I have heard the Law Council's evidence, and I think that we endorse their concerns there, that there may be NGOs with little staffing who are caught by this provision, finding themselves in possession of information that now has significant obligations attached to it. Whether they even realise that, if they do realise it, would they have the capacity to put in place the appropriate arrangements? It's a challenging one, that transitional issue, and I endorse the Law Council's concerns in relation to it.
If I go to page 3 of your submission, halfway down, recommendation 6.5, the general secrecy offence should require knowledge, intention or recklessness as to whether disclosure would harm one of the specified public interests versus what the new targeted offence does do. So that was not incorporated. And we've heard, as you've clearly been listening, to a number of submitters that have raised that the new targeted offence in section 122.4 does not require any fault element relating to harm to public interests, and literally just turns on the improper use for benefit or detriment, not on harm named public interest. You'd obviously like to see more guidance given in relation to that, in particular, given it's a criminal offence, and the more certainty you have around this, the more guidance is provided to people in receipt of the information.
Yeah, look, I think the first step is actually to better understand the justification or the mischief that the government is trying to capture in relation to its move from the harm-based offence, which was recommended and is much more consistent with the reviews, the significant body of work in the reviews and submissions that have been made to the reviews. It's quite a shift from that to this idea of the offence turning on benefit or detriment and impropriety, but if it is retained, and then yes, Senator, the concerns would be they are as currently drafted, undefined concepts in the legislation and potentially very broad. I know the Law Council makes a recommendation saying that at the least it should be in relation to material benefit or material detriment because it's not even that high a threshold at the moment.
No, thank you for that. I'm happy to pass the call. I've had a very generous amount of time.
Thanks, Senator Cash. Senator Shoebridge.
Thanks, Chair. And thanks, Professor Appleby, for the submission and for the broader work that the Centre for Public Integrity does. I know it's been greatly appreciated, the Centre's engagement in public debate, particularly on these issues of transparency and secrecy, and I just want to reflect my appreciation for the work you do. So I know we've had some of this discussion. It's touched on in your opening statement. It's touched on your submission. But one of the key concerns that I've had fed to my office is that, yes, we're getting rid of some, 300 odd secrecy provisions, but it comes at a cost. And the cost may well be too high because there's a general purpose secrecy provision that seems to extend even beyond the public service to those who engage with the public service and without the checks and balances. If you were to take a step back and look at this legislation, where do you see the balance in this legislation?
I think the concerns of the Centre for Public Integrity is that the balance that has been struck in this legislation between the repeal of the specific secrecy offences and the redrafting of the general secrecy offence is that it has not been pressure tested. And that is what we are seeing in the submissions that are being made on the substantive concerns in relation to the general secrecy offence. What does benefit mean? What does detriment mean? When is something improper? Unpaid services, does it extend to people providing pro bono expert advice when government asks them, do they have to put in place formal arrangements, etc.? There's a whole lot of questions in relation to the balance that has been struck, and I think that goes to the Centre for Public Integrity's process issue, which is that now we have legislation that the government has introduced, a welcome step forward, but it's not legislation the detail of which and the concept of which have been taken to further public consultation, particularly because it does indicate a departure from the real direction in terms of the general secrecy offence that was set in those previous reviews. So I guess the concern we have is the balance that has changed, and we see significant concerns raised in relation to that. And we're here at a stage of making submissions on a bill, and the Centre for Public Integrity thinks that it would have been a much better process point to have an exposure draft and pressure testing at that point.
Yeah, and I appreciate the Centre for Public Integrity getting a submission in the timeframe that was available. But I suspect that you would have liked more time to consult with different stakeholders, different holders of specialised information or people with perhaps lived experience with the system in order to properly engage with this. Do you think, just from your own example with the CPI, has this time frame been acceptable for you to be able to get to grips with the full implications?
Look, timeframes are always challenging. We sought an extension and it was granted in relation to our submission. The work that we wanted to do was to make sure that we properly understood the extent to which the recommendations had been fully or not fully implemented and the changes that were there in the bill. That took a significant amount of effort, and we provided that full work to the committee to help it with its work and its scrutiny work. Doing that work was significant. We're pleased that we've been able to help the committee in doing that. That meant that we were not really able to do more substantive work in relation to the provisions themselves. So as with everything, you can't do everything you always want to. Time is always helpful. But you can see from the nature of our submission that we've tried to help the committee as much as we can, but it really is process-driven at this point and relying on our previous submissions in relation to the substantive point in section 37.
And I do appreciate the way your submission points out how far this proposal deviates from those recommendations that have been handed after a much more considered process. But could I just maybe deal with a couple of those? There are kind of almost, as you read through the different submissions, we hear from different stakeholders, there are kind of two elements to concerns about the new secrecy provision. Well, there's three elements. One is its broad reach. The second is its failure to require proof of harm and what harm would mean. And the third is the failure to include a public interest defence. They seem to be the three kind of principal concerns people are raising with this new provision. Is that how you see? Are they the principal concerns you see with the provision? Are there things you want to add to that? Are there comments you'd make about those elements?
No, look, we've had the benefit of reading other submissions and listening to the evidence today from other stakeholders. And as I said, I think in particular the submissions that have been made by the Law Council of Australia resonate very strongly with the Centre for Public Integrity, not just our concerns and principles, but also the work that we do in relation to the potential capturing of unpaid services to the government. Yes, I think that's the best answer I can offer to your question. I think that it's been very interesting as well, and this is obviously the benefit of broader public consultation, to hear the concerns from journalists in relation to their specific professional role within our democracy and where their concerns lie. You see different concerns with different constituencies and stakeholders. That's the benefit of broader consultation and feedback once you have the detail of what is proposed.
And so could I ask you then about, the issue here is one of how the government should deal with secrecy provisions and what information is quite legitimately the subject of criminal penalties if it's released in the public, and where that line should be drawn. Perhaps, if you could put to one side the process to date, at a principle level, where does the CPI see that line being drawn?
Yeah, sure. The Centre for Public Integrity has endorsed and continues to endorse the need for any secrecy offences to be reserved for those circumstances where they are genuinely needed and connected to the potential harm to public interest. And that is why we have consistently endorsed the public harm approach that was in the previous recommendations, and we note that this bill departs from that and raises a number of significant concerns. So we continue to endorse that harm-based approach.
All right. And when you're talking about harm, on one view, the government being embarrassed causes harm. The government also having to expend funds to fix up a problem, if it comes at a financial cost, might meet the test of harm, even though actually there might be some essential good in fixing up a problem. The definition of harm is actually quite tricky, isn't it, in this space?
Well, I think when I say the harm-based approach, it's not a general harm-based approach, noting the potential capacious definition of harm. The Australian Law Reform Commission, for example, specified harm in relation to damaging security, defence or international relations, prejudicing criminal justice, endangering life or physical safety, or prejudicing public safety. So a very directed, defined set of harms that should then attach the criminal sanctions to.
But could I give you one example of that, just to highlight how even that definition can be quite problematic? Harming international relations. For example, there is a significant part of society that doesn't like the AUKUS arrangement with the United States. The government, other political players, think that the AUKUS arrangement is critical for Australia's international relations, and they may see harming AUKUS to be contrary to Australia's international relations. Even that definition creates a significant amount of potential overreach and potential harm to people who may have quite legitimate whistleblowing concerns.
Yeah, I certainly think that the definition of harm in any general secrecy offence, which is harm-based, would need to be carefully drawn, perhaps enunciated as needed. We don't have a bill that is a harm-based general secrecy offence for me to look at a definition in. That's what I'm saying is that's a preferred approach. Yeah. We've got a bill in which the provision instead turns on concepts that weren't part of the recommendations of that previous work, and where we had previously been thinking the direction was heading.
And this conversation about what is or isn't harm for the purpose of a secrecy provision, and I know it's not part of this bill, but it brings to fore, doesn't it, why it's important also to have a public interest defence as well, a sort of fallback provision that can provide further protection for people, even though the government may make a harm argument, allow them to run a public interest defence to prevent going to jail for a breach of secrecy. Do you agree?
Yeah. Look, I would say in relation to crafting any general secrecy offence, you need to look holistically at it. You need to look at how it operates with the defences. Are there appropriate defences that allow for genuine public interest disclosures, but also how it relates into the whistleblower or public interest disclosure legislation and how it sits with that. So I think, you need to look at it holistically and how it interacts. Again, we don't have that in front of us. That's not what we're analysing.
Well, I just give you the invitation, and the Centre for Public Integrity can take it or not, depending on your resources and capability. If there's anything in addition you would like to put on the record to this committee, based upon either the questions or what you've heard from other submissions, I'd invite you to, if you could give that assistance to the committee, I'd really appreciate it. And one of the things that comes to mind is I've found it quite disturbing as you look through the submissions to realise the extent of the secrecy, the reach of the secrecy provision may go well beyond the protective envelope of the public interest disclosure regime. And whether or not, regardless of what else happens, there should be a clear statement to the effect you can't be pinged on a secrecy provision if you don't at least have the protection of the PID scheme, whether or not that would be another fallback. But I don't mean to limit my invitation to you to assist us just to that. Thanks, Professor.
Thank you very much, Senator.
Thank you. Did you have any? No, that's good. Excellent. All right, we might leave our questions there for this afternoon. Thank you so much for your senators have indicated that you will get some questions on notice. If you please can provide that to the Secretariat by the 11th of June. And as is standard, you'll be sent a copy of the transcript of your evidence and have an opportunity to request any corrections to transcription errors. Thank you so much. We will now take a very brief suspension. Thanks so much.
Excellent.
Thanks, Joanna. Thanks, Michaela.
Thank you. We will now resume with representatives from the Australian Federal Police. Thank you so much for taking time to speak with the committee today and coming a little bit ahead of schedule. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer or superior officers to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear?
Sandra Louise Booth, Assistant Commissioner, Australian Federal Police, Cyber and Special Investigations.
Excellent.
Matthew John Gale, Commander, Special Investigations, Australian Federal Police.
Thank you so much. Would you like to make an opening statement?
Yes, thank you.
Excellent. Please proceed.
Thank you. Thank you for the opportunity to appear today as part of the review of the Secrecy Provisions Amendment, Repealing Offences Bill 2026. As outlined by the Director-General's 2025 Threat Assessment, great power competition in our region is driving heightened levels of espionage and foreign interference, the threats of which currently sit at extreme levels. In this context, Commonwealth information is highly sought after to provide advantage to foreign adversaries at the expense of Australia's national interests. From the AFP's perspective, the general secrecy offences serve as an essential function in protecting Australia and the community from harm and risk associated with information misuse and unauthorised disclosures. Secrecy offences seek to ensure that certain information is not released in a way that it could be harmful to Australia's national interests. As federal law enforcement agency, the AFP is in a unique position as we have a dual role, both as the primary investigating agency for these offences and also as an agency which deals with sensitive information. I'd also like to highlight that the AFP does not target specific sectors of the community. We target criminality, which is determined by the laws of this Parliament. In this hearing, we'll be as frank and open as possible in answering your questions. However, there will be some limitations to what we can say in a public hearing, particularly with regard to ongoing investigations and matters before the court. First and foremost, I want to say that as police, we rely on the criminal offences as set out in legislation to determine when we commence an investigation. We do not conduct criminal investigations into general mishandling of information. And while the AFP does provide advice to government based on our operational experience and expertise, the scope of offences is ultimately a policy matter for government and the Parliament. Secrecy investigations are often highly sensitive, complex, resource intensive and protracted. And as noted in our submission, we have identified there may be investigative complexities as well, particularly with some of the proposed amendments and in the existing framework also. However, we consider the full range of offences that may cover the alleged conduct, and in some cases it is possible that other offences may also apply. We support and understand the importance of ensuring the appropriate balance between the protections of sensitive information and transparency, and this is ultimately a policy decision for government and for Parliament. It's not our role to comment on policy. Our intention is to provide operational context to you from our experience of the threat, environment and our experience investigating secrecy offences. Thank you for the opportunity to appear today. We welcome your questions.
Excellent. Thank you very much. And we'll begin with Senator Cash.
Thank you. And thank you for that opening statement, and in particular at the end, the operational context. It's interesting having you up here at this side of the program because the witnesses we've had to date are actually very much coming at it from we need to actually loosen this even further. They want transparency. Everybody agrees that secrecy is important. However, I think this is the first submission, because ASPI couldn't appear, that perhaps takes a slightly different view in terms of how open this offence needs to be. So just in terms of, ASPI's made some comments in its submission that actually refers to a lot of your evidence, actually. When a respected National Security Institute reads your submission, and they have claimed that the bill weakens operational secrecy, is that a fair reading of what your position is as the AFP?
Thank you, Senator.
And it's a genuine question. We're actually really exploring in terms of the bill does need amendment. There's some consistent themes. We've got people saying the amendments need to go this way. Then we've got others saying the amendments actually need to go this way. So it's actually trying to work out where do you draw that line?
Obviously, there is a balance between what we need with regards to national security and transparency for our community. What I would say is I wouldn't see this as a weakening. I would see it as a potential complexity in the sense that the 122.4 is seeking things from us to look for, like intent.
Yes.
Intent is very difficult to prove. Intent requires us potentially to use covert powers to be able to explore a person's communications and personal devices.
Yes.
That is not available to us under the 122.4. It is available to us under other pieces of legislation. Sorry, I will.
Yeah, can you take us through that?
I saw the question in your head.
Yeah, in your submission, I noticed there were some issues in terms of the 2-year penalty, etc., and what that did or didn't allow. Could you? I hadn't actually appreciated that. Could you take us through that?
I will defer to my commander.
Yeah, no, absolutely. Whoever, I'm more than happy to. Thank you, Commander.
Thank you, Senator. This offence isn't there. The penalty is not changing, so it's a 2-year offence.
Yes, it's still the 2-year offence. Yep.
Under the Surveillance Devices Act, a relevant offence is an offence that carries a penalty of 3 years or more. So, surveillance device capabilities for us, so that could be a listening device. Other intrusive non-telecommunication intercept type capability isn't available to us in relation to an investigation for an offence of that nature. Under the Telecommunications Intercept and Access Act, there is actually provisions for telephone intercept under the secrecy provisions within that act. So we do have slightly more investigative tools that are available to us to investigate this offence, which would support, I guess, trying to prove that intent element. What we really need to weigh up, though, is the harm and how the harm is actually occurring. So once we receive a referral, we want to stop that harm immediately. So traditionally, if we get insights into a criminal investigation, we'll do some planning. We might have a period of time where we do some monitoring covertly, which would lead to some kind of overt activity and disruption. If there is elements of high harm as a result of these unauthorised disclosures, and we've satisfied the elements which are proposed, an intent to receive a benefit or cause detriment, we'd be looking to balance the use of covert powers through the TI Act versus the harm that is actually being presented to the Commonwealth. So, in response to your question, does this, if you could just recall, your question was in relation to does it
actually weaken national security?
I would be reluctant to say yes. I think.
Well, so take me through in your terms what you see the current drafting of the bill is doing and where the tweaks are needed to satisfy you that yes, we all understand that we had to make the move towards getting away from the current framework. However, we need to draw the line here.
And we do a lot of this with the way that we triage matters as they referred into the AFP. So we have a prioritisation model. We do assessments, and we require agencies that refer unauthorised disclosures into us to provide harm statements. So we can actually fairly assess the degree of harm that we are investigating, and is it proportionate to the investigative response and resources that we allocate to make sure that the outcome is in line with our broader AFP operating model. There is cases where we will get a referral and they'll be low harm matters. There'll be considerations to things like reputational damage as a result of an unauthorised disclosure, which doesn't meet any of the harm indicators. So what we do is we actually work with referring agencies to harden their operating environment, which can often include things like education sessions to their staff and guidance around some of the security measures internally to make sure that there's the right administrative controls in place, but also there is alternatives to criminal prosecution to treating perhaps administrative breaches that are lower harm. So
in the event that we can't reach that inherently harmful, if it's not clear
under the current Act,
And the proposed.
And the proposed, right, yep.
If you can't meet the inherently harmful through the referral that the referring agency is providing, then it would be difficult for us to proceed because we're not meeting the proofs, which is where Matt is saying we would need to do education with agencies who possess classified materials to ensure that they have administrative actions that they can also take where it doesn't meet a legal threshold for charge.
Do any amendments need to be made to make the legislation clearer for you or more workable from an operational context?
If I were to have one concern, it is around intent.
Yes.
Because intent is very difficult to prove, as I say, without being able to drill into a person's personal communications, devices, all the rest of it, whilst information may be relevant and available through the agency that is referring to us, through their own resources and collections, it may not necessarily go to the extent where intent is clear. Without having intent, we don't meet the proofs. I'll just defer to Matthew to make sure I have got that.
And
haven't confused anything. Sometimes it's easy to.
And then the Assistant Commissioner is quite correct under the proposed laws that would apply. In the current 122.4, the intent doesn't apply in the same manner. It's more focused on the duty not to disclose. So what we have found historically, without going into particular cases, is around proving that element as well. It's just to make sure that whether it's a non-disclosure agreement or whatever instrument is used to provide an individual with a duty not to disclose, to make sure that that is actually withstanding scrutiny if it was to go through a criminal prosecution. So there are cases where that has been a difficult element for us to prove. That remains, I believe, under the proposed new amendments, but it's captured under their role as a Commonwealth employee. So if I can just be corrected on that one. We've got the proposed one. No, the proposed new law 122.4. Apologies, I do have it here.
No, that's okay.
Where is it? Oh, here it is. Sorry. So that duty to not disclose is removed under the new offence and is replaced with that intent piece around the to receive a benefit or detriment. And we go back to the element of the person having been a Commonwealth officer or having been otherwise engaged by the Commonwealth.
So in terms of the proving of intent, and if you had difficulties with proving it, do those complaints get just deprioritised because if you can't prove intent, you're not getting to the relevant
If we can't
threshold?
prove an offence, there's no offence to investigate.
Okay. In terms of the bill removing the security classified information from the definition of inherently harmful information, can I get you to comment on that for us, please?
So if we look at the removal of the security classified information from the definition of inherently harmful information, that means that it will only capture intelligence agency information and certain law enforcement information. Sensitive information outside those categories won't be captured by the new offence.
And they previously are? Oh, they currently are?
They currently are under the 5.6.
Can you give us some examples of what won't be covered?
So, for example, secret cyber security information about an agency that holds large amounts of personal information about Australians or about an industry.
Yes. So what happens to that?
That information would not be available to us.
So we would look at...
I'm probably... Why wouldn't it be available to you? Because you'll need access to it.
True. It's just that offence provision may not apply to that particular circumstance. So we would have to look at what other legislation
we
might
could
capture
use.
that. So it could be the interference with a computer or other offences within the legislation that would be more appropriate for that particular type of offending.
How can we... Do you need us to make the legislation clearer for you to give you that certainty?
The offence provisions that we have in other acts do fill the void.
They do fill
the void.
Okay.
This
Okay.
on its own, without the support of other pieces of legislation, wouldn't.
Right.
However, we do have other acts that we can use. Is that fair?
Yes.
Yes.
Okay. Just in terms of the stripping of the security classified information from the definition of inherently harmful, one of the other arguments put forward by ASPI is they argue that stripping security classification of legal rate removes the Commonwealth's primary mechanism for signalling assessed sensitivity before harm materialises. And again, they've looked at your submission. Yes. They cite your evidence that secret and top secret markings communicate assessed risk. Do you share ASPI's concern that the bill potentially cuts too deeply here?
That's a good question.
And look, can I tell you, if you need to take things away on notice, more than happy for you to say, can we take that away and give it further consideration? Because again, this is a very genuine exploration of the bill. And for you, you might have to go away given the nature of what you do when it comes to the operational context.
If you wouldn't mind, Senator, I mean, Matt, I'm happy for you too, but I think we might take some time to get this right, but we might be able to offer some preliminary views.
There's a degree of complexity. So,
and this, keep on with this is what I'm worried about. This degree of complexity.
So the PSPF is a framework which is designed for classifications and identifying harm in relation to the nature of the information in very loose terms. That itself is not a matter of fact when going through a criminal prosecution. So just because someone produces a top secret document doesn't mean that we take it on face value as being a top secret document. So there is a process that we need to go through with the creator to get evidence of them in relation to how the document was published and why it actually meets the markers within the PSPF. So why is that actually top secret information? So
and is it still top secret information?
Right.
Correct. And then there is a process at the moment that requires the Attorney General to then certify that information is of that security classification then, which contributes towards the harmful aspect of the offence. So again, for an offence that for the inherently harmful, I think carries a penalty of 7 years.
Yes.
It is quite a complex offence, and so when we actually unpack the proofs, it is quite complex and it's very protracted. So the removal of the security classifications itself is unlikely to be overly damaging because we still have to prove the elements of the harm associated with the information through the current regime anyway.
Okay. ASPI's answer to overclassification is not to strip classification of legal relevance, but they argue that we need to streamline certification, tighten audit and set clearer statutory thresholds for when classification attracts criminal protection. From an operational standpoint, is that a better way forward than the stripping of the classification as proposed by the bill?
Again, a bit of a one that we might have to... We'll get a preliminary review
more
here,
than happy,
but we would
absolutely.
like to take this away and put some depth into it.
That would be good.
I think that there are... stripping the classification of the document at the outset is problematic for us in the sense that we're removing some of the things that we would initially be looking for.
The general guidance It's a top secret document. Yep. Okay, that's where we're starting.
So the things that I would start with, the things that our investigators would look for immediately, are not there.
So what actually happens then? If you strip that away, what do you look for?
We would look for things like sensitivities within it. We would look at the harm statement that was produced by the referring agency, because they still need to articulate the harm to us.
Yes.
And that harm needs to be beyond reputational. So there needs to be depth to that, and some information that provides clarity to what that would look like. We still need to look at, if we go back to the individual, the intent of which it was shared, and when you then look at the sensitivity within the material, what that harm then calculates to a higher effect. Do you want to add anything, Matthew?
No, I think that's.
Can you take us through the statement of harm that's currently provided under the current offence and what it will look like under the new offence? And again, if you need to take it away, as I said, please.
It'd be almost like putting into a hypothesising.
What would you need to address under the new offence as opposed to under the current offence?
Look, I think the principles would still apply because, as I said, we have to go through a certification process in relation to the documents, and the agencies will present what the impact of the unauthorised disclosure of those documents actually causes the Commonwealth. So that is the element that we're really focusing on also. So yes, the scope is somewhat narrowed with the inherently harmful information component to intelligence agencies, certain law enforcement activities and operational capability and the like. But, it's the agencies articulating to us with some degree of specificity as to what that actually harm has been caused as a result of that unauthorised disclosure. If that's not yet realised, and what the intent or what the harm may have been realised as a result of that unauthorised disclosure. So there's different elements to the offence and the investigation that we would need to explore. But we can take that away and perhaps compare the two as to whether or not.
Something.
I didn't. It's very interesting because it's a fundamentally different focus that you actually bring to how this operates, etc., versus those who just want to argue about, well, we think there should be less secrecy and more transparency without actually understanding, well, hey, hold on.
It is such a balance because the harm can be so incredible to our national security, but we also respect that there is a requirement for transparency.
It's if you looked at you have looked at the bill. What comments do you have to us as a committee in writing our report in terms of any refinements that need to be made to the legislation? As I said, I don't think anyone disputes the intent. There's been numerous reviews to get us to this point, but it's now you have drafting in front of you, you see it very differently because words have different meanings. Can you give us guidance as to what you think might need to be refined?
I'm not sure whether this would be a subject of the bill or the bill's wording. However, maybe instruction which accompanies it, which is around encouraging agencies to report harm and to report crime.
Yes.
And the reason why I say that is because it can be confronting for agencies to have to report a crime in this environment. It's having to articulate what that is to a law enforcement agency and essentially present that in what will become an open way can be confronting. So I think it's around education and making sure people understand that if you are going to report this, what is required of you to report it, and the necessity to provide certain information to enable us to conduct an investigation.
Can I jump to an issue that's been raised by others, but in particular, again, ASPI, as I said, because they have had a look at your submission. I'm going to use their phrasings. So it's the ideologically motivated leaker, and they refer to it as the Australian Snowden gap. So they raise the prospect of an Australian version of Edward Snowden, who argues that they release secret material not for personal gain and not to cause detriment, but only to reveal what they call the truth. Under the new section 122.4 as drafted, and this has been raised in other submissions, could that person, I'm not going to say walk free, that's a bad way to put it, potentially not face charge because there is no offence that captures the ideologically motivated leaker?
Thank you, Senator. I think we'd be reluctant to preempt an outcome in relation to that because criminal investigations are complex and we don't rely solely on admissions or denials from the offender in these circumstances. So I would resist providing any prediction of how that would apply, but just do note that there is other evidence that is collected to support a person's state of mind when they're committing an offence, which we would duly consider and provide through to the Commonwealth Director of Public Prosecutions in the form of a qualified advice brief before any progress would be made in that regard.
Okay. Paragraph 15 of your submission, can I get you just to expand on that, where there is no clear harm or the agency is unable or declines to provide a statement. I didn't know they could decline to provide a statement, but they can, yes. The matter is prioritised accordingly and may not meet the threshold for investigations. So is this then going to the evidentiary basis? Yep. If you don't have it, correct. If I decline to provide you with a statement, well, it's one less thing you have to go on.
Yes, so we have a process where agencies do report crime through a crime portal on the AFP website. They provide details of what the alleged offending is, and we outline what is required. The harm statement is something that we've introduced in recent years as being required at the outset of that referral because we do expend a lot of effort in building an investigation, only to go to agencies on occasion and say, "Where's your harm statement?"
And they say,
look, maybe we'll protect our capability or not proceed. So we have a process now where that harm statement is required up front, which helps us inform whether or not there is sufficient grounds to commence an investigation.
Just on that then, in terms of that statement, are you saying that the transition away from deemed harm, which is something that the bill does, would make prosecutions more difficult and therefore an investigation potentially unlikely? Because under the deemed harm, it was deemed to have harmed. Now we've moved away to there is no deeming, you now have to prove it. Is that going to make the investigation harder or the prosecution more difficult?
It's certainly going to make the harm statement more important.
It is, yeah. So I'm going to almost, if I'm not providing it to you,
it's similar to if you have an offence but you don't have a person who's stating that the offence occurred.
Yes.
Where do you begin?
Yes. It's a very good question. I didn't actually realise it was so difficult to do all of this, to be honest with you. It's actually fascinating now listening to you talk about, it's the level of investigation that you need to undertake before you can be satisfied.
But that's why, from the perspective of my colleague and being the Commander of Special Investigations, the education to departments is incredibly important in this space. Well,
that's okay. So
that's a role that we have to undertake, and a role we take seriously is education.
Just on that, then again, just going to some of the evidence that we've heard this morning, the bill commences if and when it passes on royal assent. So it literally is that overnight. You could already be in possession of information. How do you see that working, that one moment you've got the current law, the next you've got a different law, but there's no real opportunity to go out and explain that to people, and in particular, given the bill may well have a wider reach?
So the harm statement is important now under the current legislation. It is important now. So the education that we undertake with departments, which is regular, is ongoing.
Okay.
If we were holding something currently in an operational context, in a hypothetical sense, it's likely that we have already spoken to the agency involved, and we would continue to speak to them as the bill passes around any complications that might mean. Throughout the process of a harm statement, the investigators will assess what they've been provided, and there may be, backwards and forwards with, we need more about this, we need more about that. Are you able to provide evidence of this? Can you share this with us? So that will go backwards and forwards until we meet a position where we believe we have a threshold to go forward. If we don't meet that threshold, then we don't meet that threshold.
Okay. Just in terms, again, going back to the proving of the offence, again, and this is a theme that's gone throughout other submissions, but I will refer to ASPE. ASPE argues that the word improper is left undefined, and as have others, and that this creates uncertainty for officials and prosecutors alike, and it proposes a statutory list of factors, and again we've heard from another witness who said the same thing, such as classification status, clearance level, training, and whether lawful reporting channels were used. Would a defined list, not necessarily that list, but a defined list, make the offence more workable from where the AFP sits?
Well, I think the final limb of 122.4, which relates to conduct is improper, really does cover off on the duty aspect of the previous offence. So I think, getting some specification around what the definition of improper is certainly would give investigators guidance as to what they would need to prove in relation to that. However, again, these decision-making processes don't sit solely on the shoulders of a police officer that's doing the investigation. So if we are seeking definitional guidance in relation to that, we have a number of other resources that are available to us. We do use our own legal. We use AGS to give us guidance in relation to what we would be looking to prove in relation to these offences and what that definition may be, whether it's a layman's definition of the word improper out of the dictionary, or whether there's a broader legal interpretation of that particular word.
Okay.
I think too what that may do, and the way that Matt's described it, is again going back to the agency. If the definition of improper is there, it may enable them to better understand what needs to be captured, what meets the threshold to refer it to police versus what might require administrative action, because there are obligations on all agencies to make sure people within their agency are handling their material appropriately.
Well, that's interesting as well. In terms of not giving any guidance on improper and sort of the lack of definition around it, I'm assuming that, again, it goes to your role in terms of the investigation. If you can't get the evidence, you're unlikely to proceed, or you're not going to get to a final conclusion on the matter because you just don't reach a threshold. So as much guidance potentially as can be given would assist you in terms of your investigation.
And reaching that we can see criminality.
Yep, okay. Okay. The bill itself extends the offence to contractors and service providers, and the example given is the PwC matter, as proof that sensitive Commonwealth information moves well beyond permanent public servants. Do you have an opinion that former officials and external providers may well therefore become a live operational risk, that the bill, there's a gap now and we actually need to work out a way to actually reach them, that they would no longer be able to be gone after?
So I'm conscious that the Attorney-General has said previously that this does fill a gap. With regards to PwC, unfortunately, I won't be able to make comment on or draw comment to that. It is still an ongoing investigation. I think I would leave my answer there, but I will ask the Commander if he has anything else to add to that.
Now, as long as the element of them being a member of an employee of the Commonwealth or a contractor, and the due diligence is applied to that, that withstands the scrutiny under a criminal prosecution. I don't see that being a bridge too far for us to actually continue a prosecution, because it's an obligation that's on the person, which would probably I don't want to preempt, and it's perhaps a question other agencies may be more informed on responding to. But if we do have the right governance in place in relation to the way contractors or other employees are engaged, then we would proceed with this as we would with any other investigation that applies with the same need, if I could say that.
Okay. Chair, do you have any questions?
We have been diligently ticking off our questions.
Our questions as I've gone through them. I do apologise. Sorry about
you've been very
that.
thorough.
I'm just.
Our team are like, Senator Cash is asking our questions. So you've been very helpful to our crew. Thank you.
So yeah, para 14, harm is an important consideration in the way you prioritise and investigate. Okay, I've got a better understanding of that. We've gone through the security classified information. We've gone through the prioritisation of secrecy. I think
we can leave it there if you like.
I think, and I might also now digest a little bit more of what you've put to me, if that's all right, and then I will probably put just a few questions on notice, if that's all right.
Please.
That would be greatly appreciated. Yeah, completely different perspective.
Well, it's the practical.
That's what I mean, the practical, exactly, on the ground perspective.
Thank you. Thank you.
Can you actually go up? Yeah.
It's been very useful.
It's very useful. Thank you very much.
Thank you very much.
Yeah.
And again, thank you for getting here early for us. I really appreciate it. The information that questions on notice you might receive from Senator Cash or us, would you please forward that to the Secretary by the 11th of June for the committee to consider, and as is usual, you'll be sent a copy of the transcript of your evidence and have an opportunity to request any corrections to transcription errors. Thank you very much.
Thank you very much.
Take a very short suspension.
Very
We now resume with representatives from the Attorney General's Department. Thank you for taking time to speak with the committee today and coming a little bit earlier than scheduled. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to a superior officer or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, could you please state your full name and the capacity in which you appear?
Sarah Samuels, First Assistant Secretary, Integrity and Criminal Law Division, Attorney General's Department.
Luke Muffet, Assistant Secretary, National Security and Criminal Law Branch, Attorney General's Department.
Emma Squires, Director, National Security and Criminal Law Branch, Attorney General's Department.
Excellent. Do you have an opening statement you would like to make?
I do have a short
Excellent.
statement. Thanks. The Department welcomes the opportunity to appear before the committee as part of the review of the Secrecy Provisions Amendment Repealing Offences Bill 2026. Secrecy offences play an important role in protecting sensitive Commonwealth information where its inappropriate use or disclosure harms essential public interests. However, this must be appropriately balanced to uphold government transparency and accountability. The bill achieves this balance. Significantly, this bill will address the complex and inconsistent patchwork of secrecy offences that have grown across the statute book over decades, addressing provisions that are outdated, overly broad, or disproportionate. While many of the provisions in the bill are technical, to assist the committee, I wanted to provide a brief overview of the collective effect of the measures. Firstly, the bill removes criminal liability from over 300 secrecy provisions. This represents more than a 30% reduction of all existing secrecy provisions. I would like to note, in particular, this is almost double the 168 secrecy provisions that were initially identified by the Department's review of secrecy provisions. This reduction is achieved through a combination of repeals of secrecy offences and repealing existing section 122.4 of the Criminal Code that applies criminal liability to non-disclosure duties in other acts. The Department extensively consulted all departments to confirm secrecy provisions they administer could be adequately protected by existing secrecy offences or civil and administrative mechanisms. The bill also introduces a new targeted offence to close gaps in existing secrecy laws that were identified in the egregious use and disclosure of taxation information by a former PwC partner. The offence applies to persons who provide paid or unpaid services to the Commonwealth where that person improperly uses or communicates information to seek to obtain a benefit or cause detriment. The offence as introduced reflects a narrower and more targeted offence than was originally recommended by the AGD Secrecy Review, which recommended the offence to prevent disclosure of information prejudicial to the effective working of government. This narrowing is intended to ensure the offence is not inappropriately broad, while ensuring it is focused on preventing harm to the relationship of trust between the community and the Australian government. The bill provides a legislative requirement for the Attorney General's consent to prosecute a journalist for secrecy offences as an additional level of scrutiny to improve protections for press freedom. I would like to clarify here that this does not permit the Attorney General to initiate investigations or proceedings. That is the independent prerogative of law enforcement and the CDPP. But rather it provides an additional protection which would allow the Attorney General to prevent a prosecution from proceeding where it is not considered appropriate. The bill also amends other secrecy offences in the Criminal Code to implement the government's response to the independent national security legislation Monitor's Secrecy Review. In the interest of time, should I say part of that review, in the interest of time, I won't step through each of these changes, but will highlight that the bill removes security classification as a determinative threshold of harm, clarifies key definitions, and ensures an official is only subject to an aggravated offence where their conduct would cause a higher level of harm or increases their culpability. Secrecy reforms do not stop with this bill. The Department carefully scrutinises any new or amended secrecy offences for consistency with the principles in the Guide to Framing Commonwealth Offences, Infringement Notices and Enforcement Powers. This will ensure our secrecy offences are appropriate, proportionate and provide protections for press freedom where appropriate. I'd also like to thank all the Commonwealth departments who have engaged constructively with AGD over many years towards the common objective of improving the Commonwealth secrecy framework, and also thank the many civil society organisations and members of the public that have made submissions to the AGD and interim reviews and have been invaluable in shaping these reviews. Thank you again for the opportunity to appear, and we're happy to answer any questions from the committee.
Excellent. Thank you very much. We'll proceed to questions to begin with Senator Cash.
And thank you very much. And thank you for those opening statements. I'm just going to methodically move through the questions, and they're very much based on your submission, but also the other evidence and the other submissions and the issues. I'll put the issues that other submissions have raised to you to give you an opportunity to respond. In the first instance, though, is it possible to get an actual list of the 300 plus provisions, like what are they, where they came from, that have had criminal liability removed?
We'll have to take that on notice to get it to you.
No. That's fine. Just so we can work, because I have asked for this previously in another briefing, and look, it just hasn't arrived yet, so I thought, perfect, this hearing, just so we can actually have a look at them. And in particular, what would be interesting is the first AGD review said these ones.
Yeah.
The bill comes forward with these ones. How did you determine to go from here to the plus 300 in this bill?
Yeah. No, we're happy to provide on those. I think if it helps, where we get to that number of reduced secrecy offences is a combination of things. So it is the removal of specific offences which are clear in the bill because you can see a repeal, or a secrecy offence gets lowered to a non-disclosure provision.
Yes.
It's the section 122.4 which sort of has those tentacles across the statute book where it's not as clear, so we can provide a notice of all of the non-disclosure duties that had criminality applied because of 122.4.
Yes, that would be wonderful. And then when you say, though, we remove criminal liability, can we understand exactly what you're moving the criminal liability from?
Yeah, so essentially how it operates is where there is a non-disclosure duty in a piece of Commonwealth statute.
Yes.
Section 122.4 says where a Commonwealth official breaches that non-disclosure duty, it is a criminal offence.
Yes.
So that's where the criminal responsibility, or the criminal liability is coming from.
So the mere fact that you're changing that...
By repealing we sort of... it is the... It injects criminality to a non-disclosure duty.
Yes, you're taking away the criminality, but it's still an offence.
It's still a non-disclosure duty.
Correct.
Which does not have criminal liability.
Okay. Yep, okay, so we say the bill removes criminal liability for more than a third of all Commonwealth secrecy provisions. It doesn't mean that they're no longer an offence. It's they're no longer a criminal offence.
So then there is a non-disclosure duty.
Yep.
And there may be consequences for someone breaching that non-disclosure
APS
duty.
Code of Conduct,
for example. However, it's not an offence and there is no criminal liability associated with this breach.
Understood. Okay.
We'll be clear when we give the list.
That would be good.
We might give you a little intro where...
that would be perfect.
Yeah. Yes, because I think there's also a subset, to be clear, which were secrecy offences that are turned into non-disclosure duties.
Yes.
And that therefore has the effect of removing criminal liability.
Which, if we could have a look at that as well. Yeah. And then also, there was 16 non-disclosure duties across 8 acts that you preserve criminal liability for. Can we also see them? I understand the rationale, but just so we can actually see them would assist as well.
Yeah, and they are specified in the bill, but I'm happy to...
Just so we can see it all.
Lay it out for you.
Yeah, that would be wonderful. Just in terms of... Most non-disclosure duties of breach will now be handled through the APS Code of Conduct rather than the criminal law. How is the disciplinary process inside the public service a real deterrent to a public servant who may decide to leak sensitive information?
I think to start with, we have to be clear that we are talking about section 122.4 of the Criminal Code, which is that provision that injects criminal liability into those non-disclosure duties.
Yep. So you've got the other secrecy offences that sit up here.
There are a range of other secrecy
we don't touch here.
Well, so the bill does remove some standalone secrecy offences. So
some were redundant, some were
redundant, no longer needed, or were no longer needed made it in light of the new general secrecy offence as well. So just to be clear, so there will continue to be secrecy offences in the AFP Act, in the ASIO Act, in lots of other places. So they're just to step through what is deterring someone from leaving. Well, depending on their context, if they, there'll be ones preserved in the health records sort of framework as well. So there may be specific secrecy offences that continue to apply in certain circumstances. Where there is no secrecy offence that applies and it was only a non-disclosure duty that was attracting criminal liability because of 122.4, that's when we are looking at other civil or administrative remedies to address the breach of that non-disclosure
When
duty.
you say civil, what do you mean by civil?
Well, I guess if we look at a contractor, it may be a breach of contract. There could be. It depends on the circumstances of the individual and what information they are disclosing and sort of what framework they're operating under.
Right, okay. But if I'm a public servant currently employed, I'll be under the APS Code of Conduct. What happens if I've left the public service? How do you get me?
I think...
Just loving that. How do you get me?
So I think there's a few things. To come back again, of if there is an existing secrecy offence that is there, that will continue to apply at that point in time when you used or disclosed. So that offence may still get you. Under
the new regime, though, so say in a year's time, we pass the bill. In a year's time, I'd leave the public service, but at the same time, I've also breached my non-disclosure duty. It has been identified as a gap. That's what I'm just trying to work through. Technically, I have committed what used to be an offence. It's no longer an offence. It's now an APS Code of Conduct issue. Can you get me?
I don't believe the APSC has any sort of remedies available to former APS staff. What I was saying before was I was trying to distinguish where there may be other secrecy offences that applied and would then continue to apply to your conduct at that point in time. Where the only thing that was criminalising that conduct was Section 122.4, and then that is removed.
And that's removed.
I understand the APC would have limited.
Is that a gap, or that is literally that's the way it is? Once I leave the APSC, there is no way to.
So I think we would hesitate to say there's no way. I think it would be very fact dependent, I think, as to what was done, how it was done, as to whether there were remedies available and what those were, which is why I want to be very careful here in the hypothetical. Whether that remedy is worth pursuing would depend again on the facts of the
because
case.
We're talking now about a non-disclosure duty
that's right.
as opposed to a secrecy offence.
Right. I think that's a key thing too. We're saying these duties no longer require criminal sanction. And they've been assessed as a non-disclosure duty. So we are talking about not that people will be getting away with a criminal offence here. We're talking about people getting away with a non-disclosure duty which doesn't have criminal sanction.
So, I think the point is there's an objective seriousness test that's been considered as part of this exercise.
Just in terms of the PwC example, that was the leaking of confidential Treasury tax policy. That wasn't captured by the existing law, is that correct?
Yeah, that's correct.
And why was that? Just, Ms Squires, why was that?
So there were two reasons. The first was the scope of people captured by the offence.
Yes.
So the former partner of PwC was not a Commonwealth official for the purposes of secrecy offences. And the second was the nature of the information that was disclosed. So the current offences in the criminal code largely applied to disclosures of national security and law enforcement information. And that was not it wasn't information of that nature that was disclosed in the PwC incident.
Understood. And then can you just explain to us how now the offence as drafted does capture these people?
So in two ways. So again, it's picking up that category of person in terms of people who provide services to the Commonwealth. So that would capture the a situation analogous to a PwC partner situation. And the second thing is by capturing a broader categories of information in the offence where the conduct engaged in was improper and done for a benefit or a detriment to the Commonwealth, that is intended to capture the PwC-like conduct.
One of the issues that's been raised in other submissions is services to the Commonwealth is not defined. Are we putting some parameters around that? What are services to the Commonwealth intended to be?
Yeah, look, we've heard those concerns. I think it's important when we're looking at the new general secrecy offence, as with all offences, you need to meet all elements of the offence. So if we look at services in isolation, there, and particularly with the expansion where it's services including unpaid services and paid services, that's the extra bit that's sort of been added. If you look at the wide array of services provided to the Commonwealth on any given day, it is broad. There are many different types of services provided, particularly different services that get access to sensitive information, whether that is tax advisory services, if it's IT services, if it's in the health or law context. So there is a broad range of services. Trying to...
so it is intentionally broad?
It is intentionally broad to sort of reflect all of the classes of people who can access or through the provision of services and that arrangement get access to sensitive information.
Can I put an example to you then from this morning? So it was the Law Society, Law Council. I don't know if you were listening in, and they said they were looking at the breadth of it. They're providing advice to government on legislation. The legislation is confidential in nature. Someone provides pro bono service to them, but is in receipt of all of the governmental information. Pro bono, I had an interest in it. Is that person providing the service covered? That was their worry, that because there's no definition, this person will say, well, I haven't gone anywhere near this.
So they're indirectly providing a service to the Commonwealth because they provide. Is that what the question is?
So is indirect covered? Take it on notice if you have to. Like
where I'm hesitant is it will depend on the circumstances whether that service is. So let's say if we take it over into a ICT contract, someone's doing ICT services for a department, are very clearly in an arrangement and providing services to Commonwealth. If they then have a subcontractor, then I would, in that circumstance, you'd probably say yes, because they are providing the services. So it does depend on the context.
The nature of.
But to my earlier point, I think this is where we look at the collective kind of elements. Yes, it has a broad range of services, but there are two other elements that do a fair bit of
heavy lifting.
Heavy lifting on the narrowing. I mean, just to step through them. And for completeness, I'll start the first because there are four. The first is you've used or communicated information. So this is where there's been some sort of disclosure or some sort of dealing with the information. But where it gets narrowed down is the person must intend that use or disclosure intend to get a benefit for themselves or another person, or cause detriment to themselves or another person. So, and I've might preempt a couple of your questions here if you permit. There has been some queries raised about what level of benefit or detriment is required. Here, the intent is really for that to be a material benefit or a material detriment. And even the recommendation that in the AGD secrecy review that this offence is responding to was quite clear there that mere embarrassment is not a detriment for the purposes of this. So
sorry, when you say mere embarrassment, is this the ideological leaker who just wants to cause embarrassment to government because they didn't like a policy?
Yeah, so detriment is defined in the criminal code. It's defined non-exhaustively, and it talks about any disadvantage and sort of damage or loss. So it is quite broad. But then, when you put on top of that sort of, well, how is it to be interpreted by a court? And this certainly reflects our intention in how that term is to be interpreted. The court has interpreted detriment to a Commonwealth entity as meaning detriment to essential public interests, including the ordinary business of government or disruption of Commonwealth service delivery. And they found that mere embarrassment to government or criticism of government policy would not cause detriment, because these are important parts of the democratic process. So we're not talking about sort of any accusation being levelled at government, or it has to be a real material detriment, more than embarrassment, more than criticism. So I say that first when we talk about, and this is an intentional element, so the person must be intending to cause this benefit, or intending to obtain a benefit, or intending to cause this detriment. The next really critical limb that does work in narrowing is around it must be improper. So there's been some discussion around sort of impropriety as well. So if I could just clarify a few things here. Firstly, what do we mean when we say improper? So improper is also used in foreign bribery offences in the criminal code. So it's not a novel term used in the criminal code. Also, it's not a novel in the way we're using it. Really, it's looking at and how the court has interpreted it, and there's jurisprudence on this, is around the breaches. The way you've used it breaches the standard of conduct that would be expected of a person in the position of the alleged offender. So when looking at whether it was improper or not, the court would be balancing a range of factors. So the professional standards of conduct a reasonable person would expect of the accused. They'd be looking at the relationship with the government. They'd be looking at, perhaps their training on information security, any guidance provided around when the arrangement was established with the person or the information was disclosed to the person. So there are a range of factors that go to impropriety. The other piece here is around when you look at the fault element of that. So we are talking, it's a circumstance. So we are talking about someone being reckless, that it would be regarded as improper. So someone has to be aware of a substantial risk that it would be their handling of it would be regarded as improper, and in all the circumstances, it's unjustifiable to take that risk. So. Yes, there is a broad. This is to circle back to the original question 15 minutes ago. When we are talking about it, there is a broad range of services. There needs to be a broad range of services because of the many aspects of work the Commonwealth does and engages with people on and gets support from. But where the culpability comes from and where the sort of the harm focus is coming in is around someone is intentionally trying to obtain a benefit or cause a detriment. Someone is reckless that the way they've used the information, that a reasonable person would consider that improper. So someone is using the information in that way, and that's when the criminal standard comes in. So yes, when we look at services, there is a broad range of services, but in those situations, it's really an assessment of whether someone is privileged with access to sensitive information in their arrangement with the Commonwealth, and whether they go and sort of use what is essentially Commonwealth property to obtain a benefit themselves, cause a detriment to someone else. And not even that. It has to also, they have to be aware that they're doing it improperly. And taking into account all of the circumstances of that arrangement. So I think it's important when we talk about the offence that we are talking about it as all of those factors must be met before criminal, not just one.
Okay, so then can we get to the harm-based?
Yep.
And you've listened to the evidence. So the Insulum told the committee that the new Section 1 22.4 is not properly harm-based, and you will have heard the evidence and you would have read the submissions, and that this needs to be addressed. What is, and they made that recommendation. Why did you depart from that?
Look, for us, I think we have to step back to when we say something is harm-based. There was a recommendation from the AGD secrecy review that said, Mr. Squires has helpfully given me the recommendation, that said that secrecy offences should be harm-based. And to assess whether a secrecy offence is harm-based, it must, and there's three alternatives. It must either require express proof of harm, it must apply to a narrow category of information that would almost always be harmful, or it must protect a relationship of trust between individuals or entities and the Australian government. So what we are saying is we regard the new general secrecy offence as harm-based, because when someone is in arrangement with the Commonwealth and starts using information they're entrusted with to obtain a benefit for themselves or cause a material detriment to someone else, which is more than criticism, more than embarrassment, and they're doing that in a way that is does not meet the standards of propriety, that goes to the heart of the trust that the community has in government. Government has a lot of sensitive information, some of it collected by government, some of it entrusted to government by the public. If people are using that information improperly to further their own ventures or to cause harm to others, that is harmful, and it's harmful to the trust that individuals in the community have in government. So when you look at the criteria for when a secrecy offence is harm-based, we would contest that this offence
that's
is
the basic
harm-based.
foundation of it.
Yes, that is what it is seeking to address. I think when we look at the PwC incident, that there was outrage in the community and in this place as well around people, taking that privilege and using it sort of to feather their own nest. Now, that is where government loses the trust of the people. If we expand this out to look at so that's sort of tax information and the financial things, if we talk about, health records or other things or national security information, the government has the trust of the community to hold that information on its behalf, and every time someone submits an application at Centrelink and provides all that sensitive information, that they're entrusting government with looking after that information on their behalf. If someone's going to use that improperly and for a benefit to themselves or others or to a detriment, that is eroding the trust the Australian people have in the community. So we would very much contest that it is a harms-based secrecy offence.
Have you had those discussions with, say, the Insulam in terms of this continues to be their evidence, others have submitted this as well, to explain, well, hey, hold on, we understand what you said, but this is where we're coming from?
Look, to kind of go back to how this, the origins of this offence. So in the AGD secrecy review, there was a recommendation for a general secrecy offence.
Yes.
It was focused on harm to essential public interest.
Disclosures prejudicial to the working of government.
Yes.
To the effective working of government, I should say.
So that was a recommendation. What happened then was there was a feedback from civil society in particular on that formulation was too broad.
Too broad, yes. So you've narrowed the offence down.
So we sort of have responded to that.
Okay.
And it's kind of come through. And then the Insulam, received a range of feedback about that as part of his subsequent review. And then also said, if the government's to progress with a general secrecy offence, it should sort of have these characteristics. And the government's responded to that. We then, we have spoken to a range of civil society groups to explain the offence, and hopefully we have the current process of committee where they get another opportunity to weigh in. So I would say it's been an iterative development of that is shaped in response to the feedback from civil society, but I mean, we're fortunate that we have this opportunity as well for them to make further submissions to the committee, and you to sort of weigh up where the offence as introduced compares against that history through which it's sort of been shaped by.
Several submitters then also argue, and you would have seen this evidence, the term improper in the new offence is too vague to anchor a criminal charge. What's your response to that?
Look, I've spoken already a little bit about, firstly, it is not a new term in the criminal code. It is used in foreign bribery.
Yes.
So there is sort of precedent there. I think when we talk about where is the correct balance here, and we will talk a lot, you heard a lot about balance of culpability. We need a concept like that to bring that culpability into it. Impropriety has been the subject of judicial commentary. There is the courts have interpreted on a number of occasions and sort of provided some parameters about factors that would be considered in there. We've tried to outline some of those in the explanatory materials for the bill, but we think it's capable of being understood and it is sufficiently clear.
Understood. Okay. Just in terms of a lowering of the harm thresholds and the classification, which again you would have heard the evidence. So we're moving the offence in section 122.2 or the offences to a single threshold of prejudice. Is that correct?
That's correct, with the exception of the limb of that definition that relates to prosecution, investigation, etc. of criminal offences.
Yes. Can I then, just in terms of where we sit today and where we're going to, is that higher or lower, and does it make it easier or harder to prosecute? In terms of the bar?
Yeah, look, I think when we talk about easier or harder to prosecute, it's really a different scope. I think when we look at inherently harmful information and those offences, and then we look at the offences where you are looking at the harm caused, they're sort of doing different things. In the removing of the requirement for security classification to sort of be determinative of something being inherently harmful.
Yes.
So this is, that information is inherently harmful because there's big red letters at the top that say top secret.
Yes, so you're removing that?
That's been removed, and I think that Insulum has probably put it at its highest around all the challenges with relying on the protective security policy framework.
Yes.
The thing I would say there, though, is if you step through, when I'm back at my desk and I'm writing a document, I'm then required to classify it. In determining what an appropriate classification is, I have to assess under the PSPF whether, if that information was disclosed, what harm would it have. So I go through that process as a public servant to classify a document. And that is how it obtains it. So you heard evidence from the AFP, and I only caught the first half of it because I had to come up here, but talk about the process they go through to then assess whether the information is sort of harmful in there. While, yes, we are removing that as being sort of
a trigger,
independently
as the offence.
If you come to the offence around whether it would cause harm to those factors set out or is likely to cause harm to national security and the like, I think the important thing there is if someone has classified it as such, they're already saying the information in there they consider would have that harm. So it's then it is an indicator to people. When we look at sort of what is their mental awareness, if it says top secret on the top, you've got a bit of a hint there.
Don't disclose it.
That what in there?
Yes,
may be
no, but you are correct.
But it is still for the prosecution to then prove, that the mental requirement is met there and that the harm is caused or is likely to be caused. So yes, it moves it as being sort of like element is met because there's some red letters on the top tick, we can move on. We have to assess the harm. So it's a relevant factor and it will continue to be a relevant factor, but it's not a determinative factor.
So could I ask you there, so just directly on what Aspie have said, they argue that classification should remain a marker of harm within the offence framework, while the department's position is that classification is a policy tool and it's no longer a legal standard. I sort of tend to fall on the Aspie line of, in terms of, I think classification should remain a marker of harm. How do we justify that it's no longer a legal standard?
I think to go to a legal standard, it was the policy for classifying documents was never a legal standard. It was a policy document, and this is where the Insulum has provided lots of evidence and submissions and a very lengthy report talking about the appropriateness of a policy document that is able to change over time and applied by people determining criminal liability. I think if we look at the offence in context, so while it's coming out of 122.1, when we look at then at 122.2, so this is conduct of current and former Commonwealth officials, etc., causing harm to Australia's interests. So the person must communicate information intentionally and either and then be reckless as to whether the communication causes harm to Australia's interests or the communication will or is likely to cause harm to Australia's interests. So the person has to be aware of a substantial risk that the communication causes harm to Australia or is likely to. In trying to establish whether someone is aware of that risk and it's unjustifiable in circumstances to take it, this is where we say in our explanatory memorandum that classification is still relevant, because if it says on the top secret, that is giving someone the awareness that, things are called marked top secret when they have significant harm to Australia's interests, national security, and the like. So someone it can sort of make someone sort of aware of that reality and that harm. So it's not that it ceases to be a relevant factor.
Right.
It just ceases to be a determinative factor.
Understood. Okay. Can we go to Schedule 3? Okay. So the consent for prosecuting journalists. So why have you extended this to all secrecy offences and not limited it, say, to those that were set out in the Porter direction?
So to come at initially, what this measure is trying to do, it is trying to establish an additional safeguard. So as Ms Samuel said in her opening statement, this does not give the ability for the attorney to initiate an investigation or a prosecution. Law enforcement has already initiated an investigation. They prepared a brief of evidence. It's gone to the CPP. CPP assess it and say that it is in the it's in the public interest. There's reasonable prospects of success. It has gone sort of through those checks. This is an additional sort of off ramp. So this is not the Attorney General saying, I think you should go out and prosecute that journalist. The Attorney General does not have a role in directing the investigations or the activities of law enforcement. This is about ensuring there's another safeguard at the end there because of the unique sensitivities around journalists and secrecy laws, to ensure that the attorney can be another check to say, yes, it is appropriate that this proceeds. So when you sort of consider it in that context, there are various secrecy offences across the statute book that journalists may interact with. We've heard from Australia's Right to Know earlier on about how all the various ones across the statute they have to navigate. So they are saying they are interacting with these offences. So it's important that that same principle that led there to be a need for a consent to prosecute for certain offences, we don't see a distinction between why should just this narrow set of half a dozen odd secrecy offences have this protection, but not other secrecy offences that journalists may interact with. So it's about trying to provide consistency across the board of that protection.
Can I ask then, so if you say had a prosecution for crimes against humanity, the attorney's at the very beginning of the process. Nothing can happen until you've got the consent. And again, you would have heard the arguments here. The attorney's now here and you've just articulated it yourself. This work's already done. The attorney steps in here. There's no time frames as to when the consent needs to be given. This has already happened here, so I've now been charged by the police. The attorney then says, well, I'm actually not going to be consenting. How do we get over that tension of the harm to me has possibly already been done now in the public eye because of the awareness, whereas with a crime against humanity, you can't go anywhere. You heard the evidence that was raised.
Yeah, look, and thank you. I think there's a few things to distinguish. So Division 268 of the Criminal Code, which we spoke about last week, is constructed differently to this consent provision, and frankly, many of the other consent provisions across the Criminal Code. So there are dozens of consent to prosecute provisions. The vast majority of those allow for various steps in the prosecution to progress before consent is required. That is where 268 is unique, and that it really has to be initiated. The proceedings have to be brought in the name of the attorney, so that they have to be like the attorney's right there at the beginning. And those types of offences are about as serious as they get in that offence. So what we look at here is to go to the timing. There is nothing. There's nothing that says the attorney's consent must be sought at this stage or that. Really what it is around ensuring the CDPP have sufficient time to assess the evidence and be able to provide enough context in their request to the attorney to ensure the attorney's informed. Sort of saying, we're pretty sure a crime's been committed, do you consent, isn't that helpful as a safeguard? It's about ensuring that there's enough context and assessment of the evidence that the attorney can be appropriately briefed to assess whether it is appropriate. That is a distinct process from the decision to arrest and charge someone. There are operational reasons around the timing of when to arrest and charge someone. There is nothing that prevents, and it does happen from time to time, that we will have a consent to prosecute go to the Attorney General before charges are laid, before someone has been arrested. That does happen. So I think it's important that we separate the two contexts. One is around ensuring that the Attorney General has sufficient context to make an informed decision, and with the benefit of CDPP's assessment of that evidence. And one is an operational decision around, is that person likely to reoffend? Are they likely to flee the jurisdiction? There's all various factors that will go to whether AFP think it's necessary to sort of arrest perhaps early in that process, or what sort of harm they're trying to prevent, which may lead them to have a sequence where we have arrest, charge, assessment of evidence, consent, as opposed to doing that the other way around. So they're sort of they're separate things, but I don't think it's sort of helpful to conflate them too much, because they're one is around ensuring that there is enough information before the attorney to determine whether the prosecution should proceed, or in fact, if consent is provided prior to proceedings being initiated, it won't ever start.
Correct, yes. I don't know if you heard the evidence of the AFP, just in relation to the operational concerns about the new offence, including that the 2-year penalty cuts off access to investigative powers needed for information-based crimes. Can you just address that?
Look, I didn't catch all of the evidence, but I'm familiar with their submission. I understand the point they were making was around the applicability of telecommunication intersection and access and surveillance devices. Sorry, just surveillance devices, because TIA does apply? Okay, so the TIA powers are available for those offences.
why would they think they're not?
It's the surveillance device powers that I think they've submitted aren't available. So this is when we look at it, as I mentioned before, there's a balance here. What is an appropriate penalty for conduct of this nature? And then sort of flows from that is if we determine the penalty is to be set at X level, that is an indicator of how serious the conduct is, and therefore what intrusive powers we empower law enforcement to have to investigate it. So there is a threshold there. 2 years is at the lower end. There are other offences that are are higher, and certainly in the criminal code, I think there are 7 years for the 122s.
122.1.
One is 7 years, and so they're higher. What we're talking about is the new 122.4. I would note the existing 122.4
is 2 years.
Is 2 years. It's really about a balance here of what is the appropriate seriousness of an offence, and then whether it's appropriate to give certain powers to law enforcement that flow from it. A lot of those powers, and speaking at quite a high level, have a imprisonment trigger. So any offences over this imprisonment maximum penalty, and then some of them are articulated, or that relates to child sex offending or terrorism, or you can have classes like that. So in those frameworks, it's around assessing these are inherently invasive powers. A surveillance device and what you can do under that act is inherently invasive. So is it appropriate to have those powers available for an offence that Parliament has determined is serious? And it's a criminal offence, and all criminal offences are serious, but it's 2 years relative to many of the other offences there. So it's a balance in making sure that there's sort of that proportionality of investigative powers with the seriousness of offences. So that's where that one's looking.
And thank you for that explanation. Just on the commencement, if and when the bill passes, it commences on royal assent. How are you going to ensure, and I don't mean the Commonwealth departments or anything, that we know that you'll be able to communicate with them, but people who might now be captured actually know that this has taken place and there's been a change in the law and I could be in possession of information. How will you do that?
So I think when we talk about there's a few things here. We've got the public servant group, and we've got if I use that broadly and including contractors and things who are already captured by the offences. Where the change is around, we talked about people providing unpaid services to the Commonwealth and things like that. What we would intend to do should the bill pass would be, firstly, as we do for things like this, we'll put some fact sheets and guidance up on our website just as an ordinary course of action. We've worked very closely with all departments in the Commonwealth, as is reflected by how many different pieces of legislation we're amending in this, to design this offence. So they've all been commenting on it and helping shape it, because that has also been a factor in them being comfortable with criminal responsibility being removed from some of their offences. There's this new one here. So they're very aware of what that is. We'll ensure that through those same networks that helped shape this over the last few years, that they've got sufficient tools and guidance available that when they're engaging the services of someone, or they're receiving services from someone, that they can use that guidance to inform that.
Yeah, of course. They still have to be interacting with the Commonwealth.
That's really where it comes to play. So, or if they've got a long-standing relationship with someone, they can push it out through those networks. So we will still go through the other departments, because it's that connection, that nexus with the Commonwealth, which enlivens the offences. So we'll use that nexus also as the education tool. in addition to putting things on our website, which great website, encourage everyone to look at it, but isn't, not everyone will be there just checking on it every day. We hope.
No Google alert.
No. Well, I mean, I hope all you senators do have a Google alert.
We have them. It's all right.
We'll ensure
we have them.
we'll ensure you get the guidance document as well. But we'll push it through there, because it's really at that point in time when someone is sharing information with someone, whether it's
that's when you're going to have to advise me.
Part of that can be they can just click that at the back of a contract, or click that at the back of when they send them an email, just, for awareness, here's a link to the AGD website where there's some guidance there.
One more question, because I know that you've been very generous with time. Is there a reason that, given this substantial work has gone into this over a number of years, I mean, this started under us in terms of, it's been a long time to actually get here. Is there a reason that an exposure draft was not released so that people could comment on it and we could get that refinement before we bring it into the Parliament?
Ultimately, a decision to do an exposure draft is a
decision of government. Okay.
What I can say, though, is because of the deadline that the sunsetting of 122.4 has,
and we will extend that out. That will go through the Parliament.
The intention of running these dual track bills was to ensure that the committee had sufficient time. The committee seeks submissions, and I know it's not an exposure draft because it's post-introduction, but that was the intention. There was to ensure that Parliament could properly consider this in partnership with civil society.
Okay, thank you.
Could we just, I might just ask Ms Squires to clarify one thing that came up earlier around the implementation of some of the Insulam's submissions. Do you want to just clarify those first recs?
Yeah, so what we're referring to here are the Insulam recommendations that related to confining what we call the deemed harm offences, and their application to certain intelligence agency information and law enforcement information. Those recommendations aren't implemented in the bill, but they are subject to further work by the department. There's a close nexus between those offences and the espionage and foreign interference offences.
Is that why they're not part of this work?
Reviewing, yes, and so we'll consider as part of consideration of the Insulam's review of the FE offences.
We just want to make clear, because there were some suggestions earlier, well, how does the bill implement those? It doesn't implement those. There's a government response to those, and we're still working on those. But just if you were looking for how it does it, stop looking.
Yeah. It's not. You haven't deliberately withheld that from me.
You'll see that in due course. But we've said in a number of our submissions that it implements the government response to certain recommendations. I just want to make clear that not all recommendations. There's some work ongoing for those ones.
Understood. Thank you for that.
And I've just got a couple of questions very briefly before we wrap up, because again, in responding to Senator Cash's question, you've actually answered a bunch of ours. The first is about improper use, and so it's just a question about, would a non-exhaustive list of factors be of benefit to a court when determining what is considered improper use?
It certainly could assist a court to interpret that. I would note in the foreign bribery offences, which was the other example I was talking about, used as improper. There are some factors. It says the court shouldn't consider this and should consider that. So again, there is precedent for it. So it could be done to help be clear on the face of the law what the intention was, rather than relying on explanatory memorandums and other jurisprudence.
Thank you. And then we've also had a bit of discussion today about moving the definition of a journalist, and I'm curious to know what's the reason for adopting the current definition, and any issues with changing the definition.
I think it's doing two things. So, just for context, the definition adopted is the one in the dictionary for the criminal code, which is used in various other defences. There's defences for journalists for hate crimes offences, for displaying Nazi symbols. There's various journalist defences that rely on that. So we've taken an approach to be consistent with that interpretation, with that definition, because that is the one that applies across the criminal code. I think in terms of changing it, what we have to be careful is that someone doesn't seek to don a cloak of a journalist to be able to do something and then, all of a sudden go, today I feel like being a journalist, as a cover to get them out of leaking or communicating information. What it's trying to do is defend or to protect legitimate journalists. We think that construction is sufficient to capture what journalism looks like in 2026, and I accept that that is different to what journalism looked like 50 years ago, but it is looking at people who are engaging in a professional capacity, so it is flexible for the different types of journalists that would apply, but if you change it, you just have to be careful you don't make it too broad as to just be able to capture anyone that calls themselves a journalist because they're commentating on things.
Yeah. That's helpful.
Can I ask a clarifying
Yeah, sure, go for
question
it.
there, Chair? Sorry. Just in terms of, journalism looks very different now to what it did 50 years ago. In terms of influencers, online commentators, that sort of, and they are essentially publishers, how will the legislation capture them?
So it ultimately,
not capture.
It ultimately will depend on whether they meet the definition, which I'm trying to find.
And I was going to say, is the definition broad enough, or?
So if someone does something in journalistic capacity, if it's their capacity as a journalist, editor, producer, or other person involved in the process of making news reports or current affairs reports. So firstly,
it might not, because it's probably more.
Well, the important part there too is that it is not you'll hear journalists and Australia's Right to Know, they talked about with their editors and the roles of other in the process. So all of those other ones is to capture the journalistic chain of conduct.
Yeah.
When when it talks about in their professional capacity as a journalist, that's also requires there to be some level of professionalism to it. So not people acting in personal capacity, not people engaging in ad hoc commentary, not people who just sort of declare themselves to be a journalist.
Would that capture someone who is creating content online who probably wouldn't label themselves as a journalist? And that definition doesn't sound like it would label them as a journalist.
It really does depend on the facts. I think the absence of a use of the term journalist or something like that to describe what they do would...
Well, they're not doing necessarily news or and I talk about, there are people with millions of subscribers to their platforms, in some cases more than print media. I just wonder if that should be sort of maybe addressed to capture, because it's not just journalists now who are...
I guess the question is, what is the purpose here is to ensure that journalism is, that there's a proper protection. The fact that someone might have a lot of followers is not relevant to the question. The question is, what did they do and in what capacity did they do it?
Are they a journalist?
If someone is a makeup influencer...
That's not a journalist.
They're probably not a journalist, unless, there might be journalism around that.
And that's the thing, because you don't want them getting caught, because you still want those protections, I would assume, to exist so that people can...
I think it's helpful when you look at... So when we're talking about the consent to prosecute provision for the journalist protection there, so this will be a new section 123.61C, which says that, amongst the other things before it, a reasonable person would consider that the conduct of the person who is alleged to have committed the offence was engaged in by the accused in the accused's professional journalistic capacity. So it is bringing an objective standard into that as well. So where someone can't just say, I'm a journalist to acquire the impunity that comes of it, a reasonable person's going to have to go, what you're doing. And that would also apply if perhaps they subjectively perhaps regard themselves at it or present themselves at it, but a reasonable person would say what they are doing is a professional journalistic role.
But what if, so Carl Stefanovic is probably a really good example. He could play in the realm of both.
So there's plenty of circumstances
in
where
one circumstance he may be protected and in one he's not.
There are plenty of circumstances where a journalist might do something in their personal capacity, and this does not protect them in their personal capacity or in their capacity doing, you know,
But it's not a personal capacity because it's still a public profile. So he's using his...
Well, I guess I'm using the term
publishing.
personal capacity as a distinction from their capacity as a professional journalist. So they may do several other things, some of them which may well be professional things, but that is not in their journalistic capacity.
Without making any comment on Mr.
Without
Stefanovic,
commenting on any individual.
I think when his work on the, say, Today Show, you know, you said professional journalist. If he was to have a podcast, that you know, well,
should this cover it though?
No. So I think the question, the podcast is not as straightforward as a podcast is a no.
Yeah.
But if a podcast is about gardening, then and you know, I just want to share what I'm doing.
It's relevant political or legal, like there.
If it's a news podcast, news podcasting would be covered. A podcast about a completely unrelated matter would not be covered.
So what classifies as news then?
So
if you're saying here's the latest in gardening, I don't know, like it's the best fertilizer you can possibly. Like, do you get? I'm wondering.
She's got a hot tip on gardening podcast.
sorry to have raised that.
I struggle to see how they'd be in possession of Commonwealth information to be fall foul of an offence.
We're definitely getting.
We're getting off the realm of.
Thank you.
I've just got one final question that might prompt some more follow up. But there was some evidence from a Right to Know earlier in their submission that talked about 520 secrecy offences still remaining on the statute book. You talked about the ones that were removed with Senator Cash and why those were removed and why that is a good thing. Can you please explain why those 520 remain and what harm would likely flow if those offences were removed?
So, I mean, it's very difficult with 520 to give you a general answer.
I mean, we've got all
but there are a range of reasons why they're considered necessary. It may include things which are protecting very significant personal information that people provide to government. They protect law enforcement information, national security information. So it's a kind of, for each one, there is a specific reason around the seriousness of the disclosure of that information, and that is also related to the circumstances as described in that provision. So some provisions are limited only to Commonwealth officials, some have broader application. Again, it depends on the nature of the disclosure, the nature of the matter, the harm, etc. I don't know if did they raise any specific, because we can certainly respond on a specific case, but it's very hard to respond.
They talked broadly about the number of offences that still remained. So it's useful to know that you haven't just got to 300 and thought, no, we're done now.
No, we looked at everyone.
You looked at each of those offences that remain and have assessed that they are still necessary.
And certainly, if there were a specific offence on which we could assist by getting some more information, whether we hold it or could ask the relevant agency to come back, we can do that. But at a high level, there are a range of reasons. All of them are to do with the objective seriousness of the disclosure.
The only thing I'd add is when you look at this has been a whole of government effort. The Attorney General's Department does not administer all of these various pieces of legislation. So we've gone out and consulted with all of the departments in the Commonwealth and many of their agencies through them about whether each individual secrecy offence is still required. Just as an expression of the kind of the commitment to the cause that has been shown there is when that was first done with the AGD secrecy review, there was 68 identified. In that time since, and as we've continued to do that, we've doubled the number. So they are coming to this from a perspective of we're buying into the mission of simplifying here and not having redundant ones and things there. So when we look at 500, it's not because we just ran out of puff. We've had a good look and we've kept going and going and going to the point where we're confident that those remain are ones that have a legitimate reason for being there because they're protecting sensitive information.
Great. That concludes my question.
Thank you very much,
Thank you very much. I'm not sure if you asked, but I think you've taken questions on notice, actually.
Yes.
So additional information, please provide it to the Secretary by the 11th of June. And as is usual, you'll be sent a copy of the transcript of your evidence and have an opportunity to request any corrections to transcription errors. That concludes today's proceedings. We've already talked about the date for the return of questions on notice. Thank you so much to each of you who appeared today to give evidence, and to Broadcasting and the Secretariat for all their support. I declare the hearing adjourned.
Thank you. Thank you very much, Chair. And